Good morning. We're here today, the Oversight and Investigation Subcommittee of Energy and Commerce, for a hearing entitled, Does HIPAA Help or Hinder Patient Care and Public Safety? As there is a classified briefing as well as votes this morning, we're going to waive opening statements in order to get right to the witness testimony. We will allow members to submit their opening testimony for the record. At a hearing last month to address issues raised after the Newtown tragedy, some of the witnesses told the subcommittee how HIPAA had hindered their ability to care and treat for loved ones. We are going to hear from a number of folks, government representatives, professionals, parents, experts, family members. It's an important issue. I ask all members, the reason we are here is members of Congress themselves are experts and knowledgeable on many of these issues, so we appreciate your attention to this. We are here to ask questions and learn the facts about HIPAA from those who are knowledgeable of them, and remind everyone we need to maintain decorum in the committee room. Disruptions will not be tolerated, and people doing so will be discharged if needed. We also are asking members to stick closely to the time limit as we go through.
Will the Chairman yield just briefly?
Yes, I'll yield briefly.
The Chairman and I have agreed to put all of the opening statements in the record, and I think that's appropriate given this classified briefing, which was just scheduled yesterday. And out of respect to the witnesses, many of whom have come from around the country, the Chairman and I decided we really wanted to hear from the witnesses. I will say, Mr. Chairman, though, that this is really an important topic, the HIPAA issues, particularly as they relate to gun violence. And so I will be, but it's also important if we're being asked to get the U.S. militarily or otherwise involved in Syria, and this classified briefing is with the Secretary of State. So on behalf of everybody, I want to apologize to the witnesses. Some of us may be coming in and out, but we will read the testimony and we'll make sure we know what's going on. So thank you very much, Mr.
I appreciate it. I want to also let members know I communicated with Majority Leader Eric Cantor last evening, and he is having his staff working on providing a special briefing for any members who remain through this committee. You are aware that the committee is holding an investigative hearing. I say this to the witness, Mr. Rodriguez and Mr. Rothstein, and when doing so, we have the practice of taking testimony under oath. Do you have any objections to testifying under oath? Thank you. The Chair then advises you that under the rules of the House and the rules of the committee, you are entitled to be advised by counsel. Do you desire to be advised by counsel during your testimony today? Thank you. In that case, will you please rise and raise your right hand? I will swear you in. You swear that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? The records show the witnesses have answered in the affirmative. You are now under oath and subject to the penalties set forth in Title 18, Section 1001 of the United States Code. You may each now give a 5-minute opening statement, but let me introduce the witnesses for today's hearing. On the first panel, we have Mr. Leon Rodriguez. Mr. Rodriguez is the Director of the Office for Civil Rights at the Department of Health and Human Services. He oversees the administrative operations of the Civil Rights Division. We also have Professor Mark Rothstein. He has a joint appointment at the University of Louisville, Brandeis School of Law, and the School of Medicine. He also holds a Herbert F. Bohl Chair of Law and Medicine and is the founding director of the Institute for Bioethics, Health Policy, and Law at the University of Louisville School of Medicine. Gentlemen, you may begin. Make sure your microphone is on and pull close to your mouth. Thank you.
Okay. May I begin? Good morning, Mr. Chairman, Ranking Member DeGetti, and members of the subcommittee. It is an honor for me to be here today in my capacity as Director of the Office for Civil Rights at the U.S. Department of Health and Human Services, and I thank you for calling a hearing on this very important topic. As HHS's enforcement agency for civil rights and health privacy rights, OCR handles enforcement, policy development, and education for compliance of laws in those areas. Our office plays an important role in ensuring that an individual's sensitive health information remains private and secure, and that individuals are able to exercise important rights with respect to their health information. One of the underpinnings of HIPAA is that optimal health care depends for many patients on their trust that their health information remains confidential. HIPAA also ensures that health information can flow for important and necessary purposes such as patient treatment, obtaining payment for health services, and protecting the country's public health and safety. I have often said that HIPAA is meant to be a valve and not a blockage, and that it is above all meant to maximize the welfare and interests of the patient. As such, I look forward to discussing the existing flexibilities within HIPAA. HIPAA recognizes the vital role that family members play in supporting patients with significant illness, both physical and mental. I have read the family testimonies that were placed in the record and are heartbroken by them, and so therefore take seriously this committee's desire to get to the right answer on these issues. To directly address the concerns that underlie this hearing, I will discuss the paths that HIPAA offers for providers to disclose information received during treatment to protect the health and safety of other patients. For example, HIPAA permits personal health information to be used or disclosed without an individual's authorization for health treatment and payment and for the business operations of covered entities. HIPAA also permits other uses and disclosures for certain public health activities, for law enforcement purposes, and to avert serious and imminent threats to health or safety. I'd like to talk about disclosures to family members and friends of patients. This is an important area. Ordinarily, if a patient does not object to information being either shared in front of family members or friends or with family members or friends, HIPAA provides a clear avenue for disclosure in those cases. Additionally, if a patient is incapacitated, and when I say incapacitated, we mean for that word to be given its full ordinary meaning, health cares may still communicate with family and friends of the patients if the provider determines based on their professional judgment that doing so is in the best interest of the individual. And this is, I think, an important point to underscore. HIPAA is meant to revolve around the professional judgment of the provider as to what is in the best interest of the patient. It is not meant to supplant that judgment. And so, for example, a nurse can discuss a patient's medical condition in front of the patient's sister, who accompanies them to appointment. If a patient is unconscious or otherwise incapacitated, the doctor, again, can make that judgment to share information with family members. Similarly, HIPAA recognizes that professional codes, state laws, professional standards of care recognize a duty and authority to warn of situations where a patient may pose a danger to themselves or others, or may have disclosed information indicating a threat by another to either themselves or a third person. In those cases where there is a serious and imminent risk of harm to health or safety, HIPAA has a clearly recognized exception for disclosure in those cases. And when I say an imminent risk to health or safety, it's not simply the scenario of an individual going out to commit a violent crime, but in fact it covers a number of possible scenarios that a healthcare provider, particularly a mental health care provider, may encounter. We take our obligations to educate providers and patients on these flexibilities seriously. And it's for this reason that we and the administration took the initiative in January after the tragic events in Newtown to issue a letter to the nation's healthcare providers clarifying these important points. Finally, I want to talk for just a moment about the nature in which we utilize our enforcement authorities. We focus primarily on long-standing broad-based security threats. We have never taken enforcement action because a provider has decided in the best interests of a patient to disclose information to a third party. Thank you, Mr. Chairman. Thank you, Ranking Member. Thank you, members of the committee.
Thank you, Mr. Rodriguez. Mr. Rothstein, you're recognized for 5 minutes.
Mr. Chairman.
Pull the microphone close to you if you would.
Sorry. Mr. Chairman, can you hear me?
Still not on. Is it on? Pull it real close.
Mr. Chairman.
Is the microphone? Can you tell if the microphone's on?
Okay. How about now?
There we go.
Thank you.
These are government mics, so during the sequester, they're down 20%.
As is my voice, I'm afraid. Mr. Chairman and members of the subcommittee, my name is Mark Rothstein. I'm on the faculty of the University of Louisville, but I am testifying today in my individual capacity. And again, let me apologize for my laryngitis. It's seasonal, I'm afraid. In my testimony this morning, I want to make the following 3 points. First, the HIPAA privacy rule is essential to patient care and public health and safety. Second, exceptions to the privacy rule permit disclosure of health information for important public purposes. And third, additional measures could enhance the effectiveness of the privacy rule. First, ever since the Hippocratic Oath, medical codes of ethics have established the duty of physicians to maintain the confidentiality of patient health information. Without assurances of confidentiality, patients will be reluctant to divulge sensitive information about their physical and mental health, their behavior and lifestyle that could be vital to the individual's treatment. The privacy rule codifies this crucial requirement of confidentiality, which is necessary for ethical and effective individual health care. Health privacy laws also are essential to the protection of public health and safety. To illustrate, this afternoon I'll be returning home to Louisville. At lunch, I did not want my cook or server to be someone who was reluctant to get treatment for hepatitis A because of privacy concerns. I did not want as my taxi driver someone with chronic tuberculosis who was afraid to get ongoing treatment. I did not want my flight safety placed at risk by an air traffic controller with a mental health problem or a pilot with substance abuse who was deterred from obtaining behavioral health care. Confidentiality protections, therefore, serve to advance both the patient's and the public's interest. Although we were all deeply saddened by the recent horrific loss of life caused by some violent, mentally unstable individuals, we should appreciate the potential consequences if new, excessive mental health reporting requirements were enacted. Each year in the United States, there are over 38,000 suicides and over 700,000 emergency room visits caused by self-inflicted harms. An estimated 26.2% of the people in the U.S. have a diagnosed mental disorder in a given year. Any steps to lessen confidentiality protections or mandate the unnecessary disclosure of mental health information could lead vast numbers of individuals to forego mental health treatment and potentially result in significantly more suicides, self-inflicted harms, and untreated mental illness. Second, the privacy rule specifically permits a covered entity to disclose 12 types of health information of importance to the public, and therefore the privacy rule does not hinder public safety. Among these 12 categories are disclosures for public health activities, about victims of abuse, neglect, or domestic violence, for law enforcement, and to avert a serious threat to health or safety. The 12 public purpose exceptions are permissive. The privacy rule does not require any disclosures. The disclosure obligations arise from other sources, such as state public health reporting laws. The effect of the public purpose exceptions is to permit otherwise required disclosures without violating the privacy rule. Third, for the last 10 years, inadequate health professional and patient outreach and education programs have led to a lack of understanding of the privacy rule by many affected individuals and covered entities. A common problem is that some uses and disclosures permitted by the privacy rule are not allowed by some covered entities, perhaps out of ignorance or an overabundance of caution. The 2013 promulgation of the omnibus amendments to the privacy rule make it an appropriate time for HHS to start a new program of public and healthcare provider education and outreach. In conclusion, the privacy rule, I believe, is essential to individual healthcare and public health and safety. Additional efforts to increase understanding of the privacy rule by the public and covered entities, as well as revising some of the public purpose exceptions, will enhance the effectiveness of the privacy rule. I thank you for the opportunity to testify this morning.
I think both the gentlemen, let me just ask some questions. I recognize myself for 5 minutes. During the subcommittee's March 5th forum we had on severe mental illness, Pat Milam, father of a son with a serious mental illness, pointed to HIPAA as a significant obstacle to getting his son the help he needed. Mr. Milam explained that one of his son's doctors judged him to be, quote, of extremely high risk for suicide or other bad outcome, unquote, more than once, and yet failed to share this information with Pat or his wife. Matthew Milam tragically took his own life only months later while living with his parents, and it was only after Matthew's death that the Milams were able to obtain their son's medical records. Is this an example where HIPAA worked as intended? Mr. Rothstein?
No, but if HIPAA were followed to the letter, that would have permitted the disclosure.
Mr. Rodriguez, you agree with that too? Does HIPAA bar a physician or licensed provider from revealing health information to the parents of a young adult who's living with their parents? Yes or no?
No.
Rodriguez?
Under some circumstances, it might. In most circumstances, there would be paths for disclosures to those.
Paths for disclosure. Does it allow physicians to provide information to parents if the young adult is receiving care through the parent's health care plan up to age 26, as envisioned by the Affordable Care Act? So if they're still dependents, or is it an age matter? Could you tell me where that cutoff is?
Yeah, the cutoff in terms of the patient's ordinary ability to object to the provider's disclosure is the age of majority, whatever it happens to be in a particular state.
So in Pennsylvania, it's age 14. A 14-year-old could decide whether or not that information is to be disclosed. In other states, it may be 18.
It would be, yeah, I would assume ordinarily it would be 18.
Are either of you familiar with the term anosognosia? What that term means?
I am aware of it, Chairman, because I actually read the majority memorandum for this hearing. Certainly, going back to the discussion of serious incapacity and the discussion of serious and imminent risk of harm, certainly situations where that condition either renders the patient to be in a condition of incapacity or where the consequences of that condition being unaddressed are a serious risk of imminent harm to health or safety. Again, it doesn't mean going out and committing a gun crime. It can mean a variety of different things that could be extremely harmful to that patient. Then, yes, in those cases, a patient could disclose without consent.
Mr. Rothstein, would you agree?
I agree, yes.
It sounds like from what I read from your testimony and what you said here, that we may find that a lot of providers are misinterpreting or overinterpreting the laws on HIPAA that prevent them from disclosing things to patients. Is that what you're suggesting is happening here?
Chairman, we've observed in a variety of our areas of enforcement that there is anxiety about our rules in all the wrong places. If you look at where we've taken enforcement action, it's been focused on institutions that have had long-standing failures to protect the security of all of their patients' information. HIPAA was designed to respect the provider's judgment as to their patients' best interests. I think that is often, unfortunately, misunderstood, and that's one of the reasons we put that clarification.
Let me ask this, because this gets to the crux of the matter of why we're here today, and we're going to hear some testimony from some professionals, some experts, and some parents. What if the provider decides not to share the memo, the information, whatever, for those reasons? What if the patient doesn't sign a release? The patient themselves does not even recognize they have a problem. And the parents even go to court and say, we would like to have these records reviewed. In some cases, the hospital staff says, I can't release these records if a judge says we can. And the judge asks the patient says no. And yet a condition may still exist that that patient is at risk for suicide or harm to themselves or not following their treatment. What then?
So, one thing to also keep in mind in answering this question is HIPAA is not the only relevant body of law. So we're also talking about professional ethical standards. Both the American Psychiatric Association, the American Psychological Association impose clear duties of confidentiality and create exceptions as we do. And in fact, our rules are built around both those ethical duties and state law duties, such as, for example, that in the Tarasoff versus California Board of Regents case. Clearly, in the kinds of scenarios where you describe where a provider is aware, for example, of a risk of suicide, a very clear situation where we're talking about serious risk of imminent harm, HIPAA does not stand as a barrier, even in the absence of the patient's consent to disclosure. To anybody who can help the patient, that's a critical element here, to that person who can lessen or remove the threat to the patient. If that's the parents, then that is where the disclosure can go.
Thank you. I'm out of time. I'm going to go now to Ms. DeGette for 5 minutes.
Thank you, Mr. Chairman. I think we can all agree that HIPAA provides many important protections for people's medical privacy, and we have a history of bipartisan agreement that people need to be able to keep their sensitive health information private. And so I think we would agree with our witnesses on the importance of HIPAA, but also we need to recognize that in many of these mass shootings that we've seen and in many mental illness situations where someone is a risk to themselves and to their families, there there are clearly some problems with how providers and institutions are interpreting HIPAA obligations, because it seems to me if someone is a danger to themselves or to others, that would be up to the provider's decision to advise the parents or other responsible adults. Is that correct, Mr. Rodriguez?
Yes, it would be.
And Mr. Rothstein, is that correct?
Yes, I agree with that.
So I just want to say I'm not going to blindly defend HIPAA, but I think we should be very, very careful when we contemplate changes to that statute. We heard in March about providers' interpretations of HIPAA and how they can be barriers to treating not just the mentally but also the physically ill. I myself, as a parent, I have a diabetic child, and even before she was 18 years old, sometimes we had a hard time getting providers to give us information. That's not because of HIPAA. It's because the providers misinterpreted HIPAA. And so when we hear these tragic stories today, and I'm hoping I'll get back for that, I think that we need to really take that seriously, but we need to look at ways to educate providers. In the aftermath of the murder of 32 people at Virginia Tech, we learned that HIPAA interpretations prevented mental health professionals from appropriately sharing information. Misinterpretations of HIPAA and other private laws were also identified by the GAO and by President Obama's Gun Violence Task Force as an obstacle to reporting individuals who should be barred from gun ownership to the NICS background check system. And so, Mr. Rodriguez, I think you would say HHS has tried to be responsive to these concerns that interpretations of HIPAA and other privacy rules have created obstacles. Is that correct?
That's correct. That's why we.
And in fact, you sent a letter out on January 15th of this year to health providers around the country, trying to delineate exactly what HIPAA says, correct?
Yes, we did.
Now tell us why you sent this letter.
We thought that because of all the concerns about the interaction between situations where a provider is aware of information indicating danger to either the patient or others, and some of the events that we've been hearing about in recent years, that it was important to remind providers of both the duty, the permissions under HIPAA, but also to remind them to consult with their applicable ethical standards and their applicable state laws that clearly do give them a pathway to report in these kinds of situations.
Thank you. And HHS recently issued an advance notice of proposed rulemaking to solicit public comments on HIPAA and its perceived barriers to the reporting of individuals to NICS due to mental health concerns. Is that correct?
That is correct.
And can you explain very briefly why this advance notice of rulemaking is necessary and what information you're trying to collect?
Sure. In most states, reporting as to disqualifying information for NICS actually comes from the judicial system, which is not covered under HIPAA. We are aware, at least generically, about some examples. New York State, until recently, was one very clear example of states where reporting occurred from entities that are in fact covered by HIPAA, and reporting would ordinarily have been prohibited by HIPAA. We want to understand where and to what extent HIPAA is a barrier in those cases and take any appropriate steps to remove those barriers.
Okay, just one last question. Now, the Affordable Care Act, it extended insurance to dependents up to the age of 26, correct? Yes or no?
Correct.
Yes, but it didn't say that individuals up to the age of 26, maybe that's a good question for you, Mr. Rothstein. It didn't say individuals up to an age of 26 were still considered legally dependents of their parents because they're getting health insurance. Is that correct?
Yes.
And in fact, the provision of the Affordable Care Act didn't even talk about HIPAA, did it?
Correct.
That's correct. Okay, thank you. Mr. Chairman, I'd ask unanimous consent to put this January 15th, 2013 letter from the Director to providers into the record.
Without objection, we'll.
Thank you very much.
Thank you. Gentleman's time expired. Now recognize Dr. Gingrey from Georgia for 5 minutes.
Mr. Chairman, thank you, and thank you very much for calling this very important hearing. You know, I'm sitting here thinking as a physician member of the subcommittee, It's kind of ironic, isn't it, that this law passed in 1996, HIPAA, is almost like it sounds like the Hippocratic Oath, which, of course, in the first place, do no harm. It really, in a way, has nothing to do with the Hippocratic Oath, which is hundreds, if not thousands, of years old. But in a way, it does touch on that. In the first place, do no harm in regard to how you treat a patient, but also this information sharing, because if it's not done correctly, great harm. There is potential for great harm, not only to the patient, but to the general public. So I just think that I find that sort of ironic. Mr. Rodriguez, when was the last time that the Office of Civil Rights under HHS updated the Healthcare Providers Guide to the HIPAA privacy rule posted to the OCR website? And how about the Patient's Guide? Same thing.
Congressman, Doctor, we're updating on a routine basis as different issues come up. As you know, we issued a major rule that profoundly affects both consumers and providers in January of this year, and so we've been busy posting updates relevant to that rule.
That was that January 25th rule.
That's correct. Similarly, when we identified the concerns about gun violence after the Newtown shooting, we took immediate and decisive steps to put up this reminder about the manner in which HIPAA interacts with the duties to warn. We're updating our information on a very routine.
Well, these guides answer common questions about HIPAA, correct?
That's correct.
And do you ever receive input from either the general public or the healthcare providers about the effectiveness of these updates?
We do. We speak routinely to both consumer groups and provider groups. My door is always open. In fact, I took the initiative this morning to connect with several of the family members here today, because I want to hear from them. I want to know these concerns and make sure that we're getting it.
I'm going to come right back to you, but Mr. Rothstein, are you familiar with these guides? Do you have any sense of how effective they are?
Well, I'm not sure how effective they are, but I can comment generally about the outreach and education program. And with all due respect to OCR and HHS, I think we have a major problem in this area. If you read the regulations, there are ample places where these kinds of issues, the problem of notifying parents, the problem of notifying individuals who are at risk, is spelled out. But HIPAA is a very misunderstood regulation. It's misunderstood by the public. It's misunderstood by healthcare providers. And
well, let me interrupt you to say that I fully agree with you. And as a practicing physician for a long time before coming here 10 years ago, I knew that. And I think, in fact, I wonder if some physicians don't hide behind HIPAA just to move on to the next patient and not want to be bothered with aunt or an uncle or a cousin, or in regard to questions about their loved one. I hope that doesn't exist too much, but I mean it's something that we need to think about. Let me go back to the director of the Office of Civil Rights, Mr. Rodriguez. How does OCR measure? Now, I think when I was talking to you just a second ago, it sounded like it was more anecdotal from your perspective. But how does OCR measure whether the clarifications that you referenced January 25th of this year, indeed, how do you measure whether how they're working? For example, have the number of privacy rule complaints filed under the various complaint categories been trending downwards with every further clarification? Hopefully this most recent one from OCR. Does OCR keep track of this? Do you think this would be a helpful metric to track in judging the performance, your performance, of your outreach and education efforts concerning the privacy rule?
So answering the first part of your question, Congressman, the truth is our caseload has remained steady and in fact has grown slightly over the years since we commenced enforcement. We've received something in the order of I think approximately 80,000 complaints since we first began receiving it. And the amount is fairly steady. over the years. Part of what's going on here is HIPAA still, you referenced 1996, but our rules really didn't become final until 2003 and 2005. And so there's been a learning curve over the years, both for consumers and providers, to understand what HIPAA requires and what it authorizes. And we often emphasize that HIPAA is flexible and scalable, meaning that it's really meant to be designed for a very wide variety of healthcare scenarios. I agree generally that our caseload is certainly an indicator. I don't think it's the only indicator of how well folks are understanding the requirements. I certainly agree with that proposition. I think there have been surveys done. I'm not able to speak to them specifically right now in terms of where patient concerns are, where provider concerns are, but we certainly do hear a lot of anecdotal information as you described.
Mr. Chairman, thank you for allowing the witnesses to answer, and I yield back.
Thank you.
Thank you both.
I think you now recognize the gentleman from Iowa, Mr. Braley, for 5 minutes.
Thank you, Mr. Chairman, for holding this very important hearing, which deals with the ongoing struggle between patient privacy and protecting the public safety. And these are not easy issues to deal with. But I think part of the challenges we faced and part of the concerns of family members who have been dramatically impacted by our inability to solve this problem is that these particular provisions you've been talking about, Mr. Rodriguez, are commonly known as the duty to warn provisions. And yet to most of us who understand duty to warn, a duty is a mandatory obligation, not a permissive requirement. And even though I understand completely your explanation of how this permissive disclosure is then subject to state laws dealing with mandatory disclosure, I think many healthcare professionals, particularly mental health care professionals, look at the HIPAA language, see that it's permissive, and that's the end of the story for them. And I would like to hear from both of you, how are we educating the public and more specifically mental health care providers about this bridge between supposedly mandatory duty to warn provisions that are actually permissive and state law requirements that might be mandatory?
So it's one of the issues that I think the drafters of our rule in this area were attempting to tackle, because we're talking about, I think you're correct, we're talking about both duties and authorities to warn. In other words, when we're talking about the Tarasoff example, there we are talking about an actual duty to warn or to protect.
But based on state law, not based upon the language of HIPAA.
Correct. HIPAA is really meant to get out of the way of those duties and authorities and to clear a wide enough lane for those duties and authorities to be utilized and implemented by providers and for professional judgment to really be the hallmark of when disclosure occurs.
Well, one of the first forums we had on this subject, one of our witnesses was Pete Early, who wrote this book about his son's journey through the mental health system and criminal justice system. And he noted appropriately in here that in 1963, President Kennedy signed a national mental health law that authorized Congress to spend up to $3 billion in the coming decades to construct a national network of community mental health centers, and then notes on the next page that Congress never got around to funding or financing community mental health centers. So the process of deinstitutionalization, moving from state mental health institutions to community-based mental health care that was supposed to happen, instead became a process where more and more people wound up in the criminal justice system, and we now have law enforcement officers who are often providing frontline mental health care. And I think for the families of some of the victims who have experienced firsthand the loss of a loved one because of our inability to bridge this gap, especially when a patient is accompanied to a treatment facility by law enforcement officials who have a duty to protect the public safety, and they aren't provided information about the release of that patient, even though there may be a prior history of threats. How do we get to the point where we are protecting the patient's privacy and at the same time making sure that we aren't blocking the disclosure of information that can protect the public?
I certainly think we need to continue our educational efforts. And again, that's why that initiative, which incidentally was widely covered in professional media. So I think the reminder we sent in January was something that was really embraced by the mental health profession, is to remind them that at least HIPAA, I can't account for all the professional codes and state laws that also apply here, but at least HIPAA, in those kinds of situations where a danger is posed, does not stand as an obstacle to providers acting in the interest of the patient and of public safety. I think it's also worth noting, that there is a countervailing concern that patients who fear that their information will not be confidential won't get treated. And that is an equally, and I think that's why, Congressman, when you talked about that delicate and difficult balance, that is the balance that both our regulations and healthcare providers, I believe, are trying to strike.
Mr. Rothstein, one of the other concerns that Mr. Early raises is that if we have a child in a divorce proceeding or a custody proceeding, the number one role of the court system is to decide what's in the best interest of the child. That is their principal focus. And yet when we have adult patients who are getting mental health treatment, who may or may not be able to make decisions about their own treatment needs, oftentimes the legal criteria are not what's in the best interest of the patient, but protecting the patient's wishes from a legal standpoint, and that often the advocates focus on that rather than getting the best treatment option that would benefit them and society. What are the obstacles we need to face to deal with that problem?
It's a very difficult question. The immediate test would be whether the individual is competent. And if the individual is competent, healthcare providers tend to overlook all the other tests. If the individual is competent and a threat to self or others, then that overrules the competency issue. If the individual is incompetent, unable to make reasoned decisions about his or her mental health, then the confidentiality protections would not apply.
Thank you.
Thank you. Chairman's time expired. Now recognize the gentleman from North Carolina, Ms. Elmas, for 5 minutes.
Thank you, Mr. Chairman. And thank you for, again, holding this very, very important mental health hearing, especially in lieu of the forum that we had a couple of weeks ago with the family members. And, that was a very, very important, emotional, and revealing discussion that we had. Which brings me to some of the questions that I have, because I've practiced in healthcare. I'm a nurse. My husband is a general surgeon. And, HIPAA can sometimes get in the way. And as healthcare professionals, I would say that you would typically err on the side of protecting the patient's confidentiality and yourself. As a healthcare professional. Mr. Rodriguez, I'd like to ask you, since the implementation in 2003, according to my information, HHS has received over 79,920 HIPAA complaints. What is the procedure when a complaint comes in?
Sure. The first thing we do is assess whether, in fact, it's a HIPAA complaint at all, or whether the complaint is about some other issue outside of our jurisdiction. If we determine that we do have jurisdiction, we then conduct an inquiry, conduct an investigation into the allegations. If we determine that there were violations of relevant HIPAA requirements, we then work with the entity ordinarily, and I'm going to talk about the exception in terms of our monetary enforcement program, work with the entity to correct whatever the deficiencies are in their practice in order for them to going forward be compliant in those areas. Now, through HITECH, as you know, we received enhanced monetary enforcement authorities, particularly directed at concerns about the security of electronic health information. And so since HITECH was passed, our enforcement specifically focused on security rather than use and disclosure issues that we've been talking about here, has in fact grown. And in fact, it's been a priority of mine to grow our enforcement to protect the confidentiality of electronically maintained information.
Yeah, very important. Mr. Rothstein, can you tell me, there again, since implementation of HIPAA, it brings me to the next question of, have there been significant lawsuits filed? Is that something that you would have information about with alleged HIPAA violations? And when I say lawsuits, I mean against healthcare professionals.
Right. Well, HIPAA does not provide for a private cause of action.
Okay.
So there have been a few lawsuits alleging invasion of privacy or some other
It would
tort
have-
basis.
okay, so it would have
but
to
they
be-
refer to HIPAA violations, but HIPAA doesn't provide for this.
Okay, so, and there again, I get back to the issue of healthcare providers who would err on the side of, you know, less information is probably better. Just, again, always looking out for the patient and unfortunately always having to cover your own self. And that is one of my areas of concern with HIPAA, because I do believe it is kind of a gray area and is left up to too much interpretation. So, Mr. Rodriguez, my final question here, I have a little over a minute. Do you have a sense of how often hospitals and staff and actually go over the HIPAA regulations and make sure that they're up to date? Is that done on an annual basis?
It is, Congressman, variable. We actually did an audit program last year, which was another program required under HITECH, and this was a pilot. And we found a wide range. We found some institutions that take those obligations seriously, do them on a regular annual basis, ensure that new employees are trained. But there are also many providers where that is not the case. Mm-hmm. The compliance in that area is all over the board.
There again, as unfortunately so many things fall on misinformation, I think this is definitely one of those areas. So thank you very much, and I yield back the remainder of my time.
Now recognize Mr. Butterfield for 5 minutes.
Thank you, Mr. Chairman. Let me begin by thanking both of you for your testimony today. Thank you very much. It's obvious that you all are both well prepared. I will address this question to Mr. Rodriguez. Mr. Rodriguez, following the Newtown tragedy, President Obama took appropriate action by clarifying to healthcare providers in writing their duty to warn law enforcement authorities of threats of violence. First of all, is that true?
That is true. I signed the letter, but it was at the President's direction.
Okay. That was going to lead me to my next question. Was it a letter or an executive order, or what was it? It was a letter from your office.
The letter was really a reminder of existing duties under the law and also of the administration's emphasis that these authorities to warn and these duties to warn should be fully exercised to protect the public safety.
And has that action had any impact as far as you can determine?
It's had impact in the sense that there has been renewed discussion about these issues. There was extensive industry media coverage of the letter, and so therefore we believe, based on that the reminder reached the folks it needed to reach, which are those, particularly those mental health providers.
And about how many letters actually went out from your office?
They were posted on our website and then disseminated by both press release and through various listservs that HHS has.
Can you describe, Mr. Rodriguez, additional ways the Health Information Technology, HIT, for Economic and Clinical Health Act, which we passed in the Recovery Act, how it has improved privacy and security requirements for patient records?
Sure, I appreciate that question. First of all, it has done so by bringing business associates within the ambit of the privacy and security rules. That's those contractors who serve healthcare providers and in fact often come into possession of large quantities of protected health information. We now directly regulate them as we directed healthcare providers before that. It increases the penalties for violation of HIPAA, which we've used extensively for security violations. And it also establishes requirements that breaches of health information need to be reported to our office, to the affected patients, and in cases of larger breaches also be reported to relevant media that will be seen by the affected patients.
All right. My third question follows. Can you describe the training the medical professionals receive to ensure they adhere to HIPAA?
Sure. To my knowledge, I wouldn't consider this a comprehensive answer. Certainly, training on HIPAA is offered at many professional conferences. In fact, we actually have prepared a series of videos to be posted that have been posted, and several more that will be posted on Medscape, including some that are, by the way, relevant to the topic we're discussing here. that discuss various aspects of the privacy and security rules. We're particularly concerned about smaller providers who don't necessarily have the resources of larger institutions. So we're looking for opportunities to reach them. I also understand that there are medical school curricula that touch on these issues as well.
It is my understanding that healthcare providers covered by HIPAA must notify patients if the privacy of their health information is breached. What methods are used to notify those individuals?
They can be notified. They should ordinarily be notified in writing. And again, we also, in certain cases, provide for notification through the media.
All right. Finally, Mr. Rothstein, Dr. Rothstein, even with HIPAA protections, we've heard that privacy concerns can cause individuals to actually avoid treatment. I'm not sure I knew that. Could increasing information sharing through HIPAA cause fewer individuals to seek treatment?
That certainly is a concern, especially individuals who have sensitive information that they're worried will be disclosed, yes.
All right. All right, Mr. Chairman, I yield back.
Thank the gentleman. Dr. Cassidy is not a member of the Oversight and Investigation Committee, but has asked an opportunity to join us, and without objection, we'll allow him 5 minutes to ask questions. Dr. Cassidy.
Thank you, Mr. Chairman Murphy. Gentlemen, I am a practicing physician. We'll see patients this Tuesday morning, and I have a sense that you two are incredibly bright and well-versed in this law, and it's totally divorced from the reality of an ER physician seeing 20 patients in a shift, and at 3 a.m. there's a person who comes in with these issues. I'll just tell you. And I'll also tell you that physicians fear the federal government. They understand that if the federal government comes after them and grabs them in their long legal arm, the physician may ultimately win, but she is destroyed in the process. Now, I listen to what you say, how this would allow certain forms of communication. But I will also say, when I read that the maximum penalty is $1.5 million, when the physician is having their in-service on HIPAA, that's what they remember. And when they understand that, listen, it is permissible not to give information, but you may get in trouble if you do, I can tell you, that guy, that gal, seeing the patient at 3 a.m. with 20 patients doesn't have your expertise, but what they do have are examples of physicians who have been grabbed by the law and not let loose until every one of their personal resources have been exhausted. Now, that is just a comment born out of incredible frustration with this sense that the federal government is this benign entity that the American people have no reason to fear. Indeed, it has great reason to fear, and so people act cautiously. Now, that said, after my rant, I apologize. Let me ask a couple things. We say that the doc may communicate with the family if there is imminent danger, but what if the patient is non-compliant? Can the family say to the mother of the adult child who lives with her, your son's not taking his medicines, and therefore we need to do something about that? Can the physician do that?
So, again, we go back to the idea of serious risk to health or safety. So we're not talking about imminent danger in the sense of somebody going out. I mean, it certainly includes that scenario, but it's much broader than that. So if the patient's health would be seriously adversely affected and the provider's communication of that information to the parent would provide a way of eliminating or at least reducing that threat, then HIPAA provides them clear authority.
So the specific example, the patient has bipolar, and I'm a little rusty on my site, but so this medicine may no longer be used. But assume that they're on lithium and their lithium level shows that it's low, the patient is not taking their drug. We have documented fact. Can the doc say to the mom, your son's not taking his lithium?
You also might have heard the beginning of my testimony. We were also talking in cases of incapacity.
Of what? I'm sorry?
Of incapacity.
No, I'm not saying they're incapacitated, because when that level falls, they don't immediately become incapacitated. They are just on the potential verge of being, but they could still seem sane.
Well, then I think the pathway is if the result of that would be a serious consequences for that individual's health, then HIPAA provides a path for those communications.
There seems to be a little bit of wiggle room there. The guy could get back on his dose and bring it back up to snuff. I'm not sure the physician would find a safe harbor in that kind of answer.
Well, I think the greater safe harbor, Congressman, would be this. We've received 80,000 cases since we began enforcing. Only 12 of them have resulted in monetary penalties.
I accept that, but what you're talking about is a fellow seeing patients 20 in a shift at 3 a.m. in the morning who doesn't have your expertise. That is the reality. And I can tell you that what you hear in that in-service is that if you violate HIPAA, they're going to turn you every which way but loose. I can tell you that's what the in-service is because I've been there.
I would love to see those in-services because they're not consistent with our enforcement history.
Secondly, what if it says here that the patient, healthcare provider is not permitted to share personal information with the family or friends of an adult who tells the provider not to do so? What if that patient is incompetent? What if they actually, at this point in time, are not lucid? They think that there's black helicopters circulating and that their mom is in the pilot of one of them.
And that's why I mentioned that it's certainly in cases of incapacity, and certainly incapacity can include a situation where a patient is far from lucid. Then in those cases there is also a basis.
Now, sometimes lack of lucidity is in the eye of the beholder. I will tell you that there's a Wall Street Journal article about William Bryce, or Bruce, I forget which, in which the young man was released and went out and killed his mother with a hatchet. And so clearly he was considered loose enough to be released. I'm sorry, I'm out of time. I apologize. I'll have to forego. I yield back. I'm sorry.
The chair is going to ask that everybody be permitted 1 minute of additional questions, then we'll get on to our next panel, recognizing we have votes coming up soon. So we'll do 1 minute. Mr. Rodriguez, as you are aware, states have said confusion over HIPAA has prohibited them from sharing 1.5 million records with the National Instant Background Check System of persons who have been involuntarily committed to mental health treatment or deemed mentally incompetent by a court of law and are therefore prohibited from owning a firearm. Our committee sent a letter to HHS on February 13th asking about HIPAA interfering with this next list. I note that HHS has now announced it would be soliciting feedback on HIPAA reform. Why do you believe states are not uploading those records?
I certainly have heard of HIPAA as one of several different reasons, so I don't understand HIPAA to be the only reason. I know certainly in the case of New York State, their reporting was coming out of, or their reporting would have had to have come out of what was a HIPAA-covered entity, and therefore reporting would have been prohibited. And we're now looking to eliminate that kind of barrier. Beyond New York, I don't know if there are others.
Can you get us a written response to this subcommittee on this issue, clarifying?
Sure.
HIPAA? Thank you.
Sure.
Mr. Braley, 1 minute.
Ms. Rothstein, we were talking earlier about some of the challenges faced with the incredible burdens placed on law enforcement officials, our penal systems to provide frontline mental health care. This has been a dramatic shift in what's happened since Congress passed legislation trying to promote community-based mental health. So we now have this long learning experience, and people who care about the rights of the mentally ill, like I do, people who care about protecting public safety, like I do, want to know what we've learned from these experiences as we move forward and try to create a balanced system that is protecting the public and the rights of patients to get the best possible treatment when obviously we have been failing them. What can we do about that?
Well, Mr. Braley, it's a difficult question. On the one hand, we need to increase the funding and wherewithal of community mental health services. That's for sure. What we can address at this hearing today is the importance of getting out the message of what HIPAA does and does not require. One of the problems overall is that HIPAA was intended to be a floor above which medical ethics and state law would take place. But in many areas, including mental health areas, it's the floor and there's nothing else above it.
You can offer a written response to that, too. We'd appreciate that because we recognize these more detailed. Dr. Gingrey, you're recognized for 1 minute.
Mr. Chairman, thank you. I don't know if I can do this in a minute, but quickly. Mr. Rodriguez, on January 25th, 2013, HHS published a final rule that makes, and I quote, significant modifications to marketing by third parties to patients for purposes of identifying potential beneficial health opportunities for patients. For instance, many drug companies use third parties to help identify patients in need of care for purposes of inclusion in clinical trials. Some of these patients, including those from my own district, have chronic illnesses for which no other treatment option exists. Would this service still be allowed if such a company, third-party company, did not first get the patient's consent?
It's a long answer, so I will take advantage of the opportunity to talk in writing.
All right, thank you. Thank you, and I yield back.
Dr. Cassidy, 1 minute.
Mr. Rothstein, I'm a little concerned. You mentioned the point there's 26% of the people who have a diagnosed mental order and disorder in 1 year. But that really, if you talk about serious mental illness, it's really a much smaller percentage.
Of course.
And those are the folks who are incompetent that, I mean, believe me, I speak from personal experience of family members and of friends who've been in this situation. Don't you think it's a little disingenuous to say, okay, here's a group that truly are out of it, as opposed to this 26% that have situational depression or something like this? Wouldn't it be more honest to kind of focus upon that SMI group as a, for their sake, their family's sake, as a unique group?
Oh, absolutely. But the point I was trying to make was, if legislation were enacted that made all mental health records more disclosable.
So you would accept maybe SMI under very guarded circumstances?
Of course.
As opposed to the broader 26% of the population?
That's correct. But I'm worried about the discouragement of the 26%.
I'll just say, someone who has got bipolar or schizoaffective oftentimes does not have that insight. And I think we have to be kind of honest about that. They have an acute break, and they have no insight whatsoever. As a guy who's worked with such patients and who's had close people associated. I yield back. Thank you.
Thank you. Mr. Rodriguez, Mr. Rothstein, thank you so much for being with us today, and we appreciate your availability in the future to respond to questions. As they are stepping up, and we ask the folks to get ready for the second panel, I'd like to make an announcement. As we continue on with our previous hearing on after Newtown, and also this one on HIPAA, this committee is exploring the issues of a wide range that deal with mental illness and proper treatment, et cetera, because of our concerns. I want to make it very clear for all members aware of this, but certainly members of the audience and people who may be watching this also. At no time does this committee at any time communicate that those with mental illness are those who are responsible for violence. We recognize that victims, that they are actually 11 times more likely to be victims of violent crime than non-mentally ill. And the vast majority of people with mental illness are not violent. It's very important we understand that. Could the next panel please take their seats, and we'll move forward then. As you sit down, I'll be introducing you. On the second panel, we have Dr. Richard Martini. He is a professor of pediatrics and psychiatry at the University of Utah School of Medicine and the chair of the Department of Psychiatry and Behavioral Health at the Primary Children's Medical Center in Utah. For full disclosure, I want to say when I was on the staff at Children's Hospital Pittsburgh, he was one of my students. How time flies. We also have Ms. Carol Levine. She directs the United Hospitals Funds Families and Healthcare Project, which focuses on developing partnerships between healthcare professionals and family caregivers, especially during transition healthcare settings. Next, we have Mr. Greg Wolf. Mr. Wolf is a father of a son who suffered from mental illness and substance addiction. Then we have Mr. Edward Kelly. Mr. Kelly is also a father of a son with mental illness. And Mr. Braley, would you like to also recognize your guest today?
Yes, thank you, Mr. Chairman. I'm thrilled to have one of my constituents testify today, Jan Thomas from Parkersburg, Iowa. She has a story to tell about this gentleman who was featured in Sports Illustrated after he was gunned down by a former student. He was the NFL National High School Coach of the Year with 4 of his former players playing in the National Football League, and Jan has an important story to share with us about these issues.
Thank you. And finally, we have Ms. Devin McGraw. Ms. McGraw is the Director of Health Privacy Project at the Center for Democracy and Technology. As you're all aware, the committee is holding an investigative hearing, and when doing so, has a practice of taking testimony under oath. Do any of you have any objections to testifying under oath? The chair then advises that under the rules of the House and rules of the committee, you are entitled to be advised by counsel. Do you desire to be advised by counsel during your testimony today? All answer negatively. In that case, would you all please rise and raise your right hand, and I will swear you in. If you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth. Chair recognizes all the participants answered in the affirmative. You are now under oath and subject to the penalties set forth in Title 18, Section 1001 of the United States Code. You may now give a 5-minute summary of your written testimony. We now recognize Dr. Martini for 5 minutes. Make sure your microphone is on and pull close. Thank you.
Let me see, is it on now? Okay, fine, thank you. Good morning, Chairman Murphy, members of the subcommittee. I also want to say I'm also an immediate past board member of the American Academy of Child and Adolescent Psychiatry who paid for my travel here today. Thank you for inviting me to come and to speak with you about HIPAA and its implications in clinical practice and to participate in this discussion. Throughout my testimony, I will be reviewing patient summaries that are based upon my clinical experience, but that do not include easily identifiable information. Decisions about the release of psychiatric information are certainly more straightforward when the patient is a minor and not emancipated. Parents or primary caregivers are involved in the process, are available not only to support the patient, but also to guide them into psychiatric care. Young patients do not typically recognize the nature or extent of their behavioral and emotional problems, and this is one reason why child and adolescent psychiatrists, as well as other pediatric mental health professionals, are trained to involve families in diagnosis and treatment. We also know that this improves outcome. All pediatric specialties struggle with the transition of patients from adolescence into young adulthood, from a period of dependence to a period of almost complete autonomy. Many are not prepared for the responsibility, particularly those patients that experience chronic medical illnesses, developmental delays, and psychiatric disorders. Families have provided a framework for their care and for many aspects of their life. One of my patients, a former patient with a mild form of autism, developmental delay, and anxiety disorder, was determined to move out of the home once he was employed. The parents knew, however, that he could not manage his money, that he was emotionally reactive when faced with new experiences, and he really could not track his medications. Nevertheless, he did not want his parents involved in routine care. It forced the parents to go to court, state that their son was not able to care for himself and must be dependent. Unfortunately, the subsequent ruling in their favor was counter to our goals in psychiatric treatment, and it derailed his progress in therapy. Psychiatrists spend a lot of time negotiating communications between parents and their children. We don't want to discourage anyone from accessing care, specifically those who will not seek treatment if they believe that someone will contact or involve their parents. However, the application of HIPAA regulations should be a negotiation with several options available to both the clinician and the patient. A patient of mine in his early 20s suffered from a long history of congenital kidney disease. He was in and out of the hospital, usually in the company of his mother. He came into treatment because he was angry and depressed over the circumstances of his disease and his subsequent organ transplantation. I wanted to involve the mother in therapy as a support, but he refused because he was concerned about how disappointed she would be given everything that they'd gone through together. He was in treatment for about a year, and he was on antidepressant medications, but dropped out of treatment because it was too difficult. 2 years later, I ran into his physician, who told me that he discontinued his kidney medications, went into renal failure, and died. Psychiatrists should be able to both respect the individuality of the adolescent or young adult under the legal protection of HIPAA and use the strengths of the family when necessary to support treatment. I recognize that allowing more communication and less privacy for an adult patient at risk for a serious mental illness is a significant change in the intent of the law. But must we wait for a patient to be considered at risk for imminent harm to self or others before seeking help from parents or family? Rules about confidentiality certainly affect situations that are relatively more common among adolescents and young adults, like going to college. Parents are told that even though they're going to be paying the bills, they will not have access to any medical or psychiatric information without the student's permission. One such patient, with a history of congenital heart disease and ongoing depression, wanted to go away to college. Her parents wanted her to stay close to home. She prevailed, but within 3 months of going to school, she began to deteriorate both medically and psychiatrically. The student health center knew that she was ill, but without her permission could not contact the parents. If this patient had a really serious disorder with immediate consequences, the family may not find out about it until they receive a bill some 30 days after the event. If there is a bias in these situations, should it be toward parental involvement more than away from it? Mental health professionals strive to do what's in the best interest of the patient while preserving his or her right to privacy and protection under the law. The basis for civil commitment and family communication, regardless of the patient's wishes, has been risk of harm to self or others. I suggest that the standard be re-examined with the goal of involving families whenever possible. Thank you, Mr. Chairman.
Thank you. Ms. Levine, you're recognized for 5 minutes.
Thank you very much. I'm sorry. Oops, okay. Chairman Murphy, members of the committee, thank you very much for inviting me here today. I'm at the other end of the age spectrum. I work with family caregivers of older adults who are with multiple chronic illnesses. And I think the importance of my experience for your deliberations is that the misinterpretations of HIPAA, which we've heard about from Mr. Rodriguez and Mr. Rothstein, are far more pervasive than the specific questions of mental illness. There are about 42 million Americans who are taking care of their chronically ill older parents or other relatives. And I can't tell you how many times I hear from family caregivers who have a parent in a hospital and the family members expected to do wound care, multiple medications, monitor machines, and all sorts of, make all the care coordination in the community. And when you ask about what do I need to know to do this, they said, well, I can't tell you because of HIPAA. Now, that's just simply wrong. And why does it happen? Because of the two features that have already been mentioned. There is this training that emphasizes the scary aspects of HIPAA. It is often done in a way that says, if you say anything, you're going to be in big trouble. And if the training doesn't say that, then the informal communication among healthcare providers, particularly sort of mid-level staff, which not necessarily physicians, but nurses, social workers, others, terrified that they're going to get sued, they're going to lose their job. Meanwhile, laptops lie all over the place, and they're not paying attention to the actual security of this information. The second reason, and I think this is very pervasive, also alluded to, HIPAA has become a very convenient excuse to avoid difficult conversations with families. It takes time. It's sometimes uncomfortable. It has really nothing to do with privacy of the patient's information. It has to do with, why do I have to talk to this daughter? Why can't I just tell the patient? Well, fine, if the patient is totally able to understand. But an 85-year-old woman with a congestive heart failure, moderate dementia, 55 other medications and so forth, just cannot absorb that information. So I think that what we really need is far more education on a balanced level. I think it's instructive that our United Hospital Fund's Next Step in Care website for guides for family caregivers, the most downloaded guide is the one to HIPAA. So people are confused and they're looking for information. And I think that hospitals, the covered entities, wherever they are, need to be encouraged to provide understandable information to their patients, to the families, to everyone they deal with. You go to a hospital now, you get a piece of paper to sign or several pieces of paper, you can barely understand. I think only Mr. Rothstein and Mr. Rodriguez and several members of the committee here would actually be able to understand it. And mostly, it's about what we can do with your information. It's not about protecting the patient's interests at all. I think my ultimate question is always, whose interests are being protected? Is it the patient's interests? Is it the staff members' interest in not getting into trouble? I appreciate that. Or is it the institution's interest in not making any kind of, not being in trouble? And those are valid, but they should never override the good clinical care, the importance of good communication, that older people, younger people, everyone needs to get the best possible clinical care. So it's a very pervasive problem. It goes beyond what you're specifically asking about, but I think in all, it's a kind of waterfall. Once it starts, it keeps going. And we continue to hope for more clarification. Thank you.
Thank you. Mr. Wolf, you're recognized for 5 minutes.
Good morning, Chairman Murphy and members of the Oversight Committee. My name is Greg Wolf, CEO of Kaplan, Lehman & Wolf, Court Reporting and Litigation Support and Federal Official Court Reporter for the Eastern District of Pennsylvania. I am very thankful for the invitation extended to me so that I may testify to address the necessary and dire need to change the HIPAA law regarding minors and legally emancipated adults who either have a mental disorder, disability, or drug and or alcohol addiction. I will set forth the reasoning for the exception to our valuable HIPAA law, which will have a positive impact on our society. My son Justin was a gregarious, affectionate, caring, compassionate, and intelligent young man whose life came to a sudden end on December 19, 2012 from a heroin overdose at the very young age of 21. Justin had attended Drexel and Syracuse universities for his freshman and sophomore years respectively, carried a 3.0 GPA, but each year ended poorly due to aberrant behavior. Justin had been seeing therapists since he was 15 and a half due to anxiety, OCD, and ADHD. He was placed on Adderall when he was almost 17 years old. Unlike physical illness, mental illness has a much longer maturation and duration until one discovers the effects and results with which to treat and possibly cure. In 2012, Justin told his mother that he was addicted to Percocets and OxyContin. She in turn took him to our primary care physician without my knowledge, per Justin's request. At that time, Justin apprised the doctor of his addiction, but also when his mother was not present in the room, he stated that he had been using heroin for a few months prior to that date. Justin had asked that I not be apprised of any of those substances and did not want his mother being informed of his heroin usage. Without disclosure, the heroin usage, the doctor expressed dire concern to Justin's mother, told her to take him immediately to a recommended crisis center for treatment. However, upon departing the office, Justin convinced his mother, through his drug manipulative behavior, to take him instead to a Suboxone doctor he knew of, which she did. Justin would not allow his mother into the treatment room. There, Justin admitted to using heroin for the previous year, and he was prescribed Suboxone. 2 months later, against Justin's wishes, I was only informed of his Percocet addiction and implored him to enter into drug rehabilitation treatment. Justin was working 2 jobs during this time with little time to attend treatment. Additionally, he convinced his mother and I that Suboxone was helping him with his recovery. As another month passed, Justin was residing in his college apartment, and he finally hit rock bottom. We finally gave him an ultimatum, and he entered intensive outpatient treatment for 5 weeks that summer. Once in rehab, I contacted the intake director to inquire about his progress. I was informed that he could not disclose any information under the HIPAA regulations. I was extremely frustrated as I could not be apprised of my son's condition. During Justin's 5-week rehabilitation, I sent him to see an experienced psychiatrist weekly, which ensued until his ultimate demise this past December. I explained to the psychiatrist his history with abuse, for which he tried to counsel Justin, as well as to prescribe medication for his depression, anxiety, and OCD. I later learned, however, upon Justin's passing, that he had not disclosed his heroin addiction to the psychiatrist, except to say that he had tried it once. Upon Justin's passing, his depression and OCD medication were found untouched in his apartment. Oddly, he continued to take his anxiety medication. Justin returned to school last fall at Temple University, where he appeared to be doing well. He even joined HIPAA, a wonderful fraternity where he pledged and was fully supported by the Brotherhood. However, Justin obviously was terribly and secretly addicted to heroin. In addition to having mental disorders, he died of an accidental heroin overdose, just a few weeks later. Though doctors knew since May 2011, no one in our family was aware that Justin was using heroin, a lethal and insidious drug. Everyone was in shock and disbelief when we found out. Nevertheless, it was too late. I have confronted numerous parents, and 9 out of 10 people are not aware that snorting heroin is an option, which is how Justin used the drug, not by injection. Most are also shocked to learn that heroin is only $5 to $10 a bag. It was alarming to learn that it is actually cheaper to buy a bag of heroin on the street than it is to purchase Percocet and OxyContin. Even kids from affluent suburban neighborhoods like my son traveled to dangerous places like Camden, New Jersey, and North Philadelphia in Pennsylvania to buy drugs. Justin sold some of his personal belongings and items stolen from his mother, pawned his computer on several occasions, and actually sold his Suboxone and Adderall medication, which I learned after the fact by reading his text messages. I hereby request an exception be added to HIPAA, allowing parents of minors with a mental disorder or addiction who maintain legal residency in their parents' homes, living under the auspices of their parents' care and who are under their parents' health insurance coverage, as specified by President Obama, until the age of 26, access to that minor's medical records for the following reason: prevention of harm to individuals and to society. 1, any type of addiction or mental disorder can be life-threatening to not only oneself, but to society as a whole, as indicative of the Newtown massacres, Columbine, the Aurora shootings, to name just a few. Justin was violent and would never intentionally hurt a soul, but unintentionally his life cut short destroyed other lives, including his younger brother Austin, who was a type 1 diabetic, not to mention the individuals to whom he sold his Suboxone and Adderall. After Justin's passing, Austin told us of his reckless disregard when driving, as well as when conducting some of his activities. Thank God he never hurt anyone on the road. I have pictures of Justin's apartment from his last months that demonstrate how he resided at college, including cigarette burns in his bedding from obviously nodding out, which could have set the apartment complex ablaze, resulting in injury or death to himself and others. 2, Justin's stepfather had taken him assault rifle target shooting on occasion for sport. Had we known about his heroin addiction, he would not have armed him. Justin had often asked my permission to become licensed to buy a gun, which I was against despite not knowing about his addiction. However, I am forever thankful for not allowing it, especially now that I know he was using a mind-bending drug.
Mr. Wolf, I know we're out of time. Can you give a final summary, and we can have you come back to that elements too? Is there a final summary you can give to your statement there?
I do. I have some very important points to make, and it will only take 3 or 4 more minutes.
I'll give you an additional minute. Go ahead.
Thank you. 3, Justin's lying and manipulation was the result of his heroin addiction. I have learned that heroin rewires the synapses of the brain, so the only way to experience pleasure is by doing more of the drug. One becomes numb to all other surroundings, emotions, and empathy, thereby resulting in the aforementioned behavior. Drug-related deaths have risen steadily over the last 11 years, according to a study from the Center for Disease Control. In 2010, drug overdoses killed 38,000 people, making drugs a more common cause of death than car accidents, guns, or alcohol. By comparison, approximately 8,500 homicides were the result of firearms. According to a 2011 article in Psychology Today, accidental drug overdosing is the second most cause of death of young people in the U.S., exceeding attributable to firearms, homicides, or HIV/AIDS. According to the U.S. Department of Health and Human Services, with an immature prefrontal cortex, which does not develop until 24 to 25 years old, even if teens understand that something is dangerous, they may still go ahead and engage in risky behavior. With young adults not having their frontal cortex fully developed, those with mental disorders and or addictions exacerbate the irrational behavior. In many circumstances, parents know what's best for their children, especially if given the appropriate medical information with which to exercise judgment and guidance. In an effort to help other parents in similar situations, I've launched an all-out campaign to the media, President Obama, lawmakers in New Jersey, Pennsylvania, and Delaware, and congressional leaders such as yourselves to call attention to this issue and to lobby for adding additional language to HIPAA that may help protect the troubled young adults and their communities from harm. Parents are unable to operate effectively in a vacuum without knowledge by healthcare professionals about our drug-induced or mentally disabled, legally aged children who do not have the wherewithal to reason or think rationally for themselves. The absence of rationale may result in life-threatening decisions or, as in my son's case, premature death. HIPAA has exceptions for public health and safety built in. Item number 5 under permitted uses and disclosures whereby protected health information can be disclosed without an individual's consent, including serious threat to health or safety. Covered entities may disclose protected health information that they believe is necessary to prevent or lessen a serious and imminent threat to a person or the public when such disclosure is made to someone they believe can prevent or lessen the threat, including the target of that threat. So it should stand to reason language addressing the particular safety hazard is prudent and necessary. In closing, I am hereby requesting the following language be added to this HIPAA exception to avoid ambiguity. Parents or legal caretakers of a minor and or emancipated adult with documented drug abuse and or mental health histories who continue to cover the minor and or emancipated adult with health coverage and or continue to support the individual financially will have access to that individual's health care records until the age of 26 to prevent him, her, or society from harm. Although Justin's family, friends, nor Justin himself could not save him, it is my hope that with change, Justin's situation can help save millions of young lives in the future. Addiction and mental disabilities wreak havoc on our society and affect all ethnicities and socioeconomic backgrounds. When you look at all the famous and intelligent people whose lives were tragically taken due to mental disturbances and drug abuse, this country has lost a wealth of talent and success, which would have been an asset to the growth and strength of our nation. Thank you very much.
Thank you. Mr. Kelly, recognized for 5 minutes. Mr. Kelly.
Can you hear me now? Thank you, Mr. Chairman. I'm a father of a paranoid schizophrenic son. He was diagnosed at age 14, which means for half his life he's had this illness. And I'm afraid I have some rather harsh news and some points to make that are going to fall in line, and I thank Congressman Cassidy for his comments because he really gets right to the point. My wife and I, upon learning of this diagnosis, embarked upon educating ourselves in every aspect of mental health treatment, including navigating the system, familiarizing ourselves with all the things that are in our way. And then we took upon ourselves to go out and educate others. And we've done that by teaching classes. We've done that by serving on boards. We've done that by speaking engagements. We've done that by raising money. And we've also done that by bringing people into our home and comforting them and helping them to cope. And so what I'm going to tell you is that we are actually ashamed of ourselves as to what we did not know before our son became mentally ill. And I would dare say that if the members of this committee were to spend a couple of days with someone with psychosis, this would fly. You would change things tomorrow. And so what needs to happen is there needs to be recognition that there's a gaping hole. And I want to clarify something. There's a difference between anosognosia, which is lack of insight, and a psychotic episode. They're two entirely different things. Anosognosia can last for long, long periods of time, and lack of insight, and you refuse treatment, and you don't want anybody to help you of any kind, most importantly, your family members, not just parents, brothers, sisters, grandparents. And so what happens is you're setting a stage for tragedy, literally propping it up, because there's this gaping hole. We're trying to teach, or we're trying to address the needs of the severely mentally ill the same way we are the mainstream mentally ill population, and it doesn't work. It's illogical. My son has thought he's been a U.S. Marshal looking for his gun. He's thought aliens were invading him. He thought he was a secret agent. He thinks to this day he served in 2 Iraqi wars. He's been naked in the snow. He's lived homeless under a bridge. He thinks my wife is a stripper and a prostitute and that I'm a sexual predator. For an entire year, he did not believe that we were his parents. Now, you tell me that this individual can possibly make responsible decisions about his care. But when he gets into the hospital, and that's a big if, because sometimes we don't have the recent history from prior hospitalizations to give the new hospital. But by the way, he's been in for 14 years, he's been in 8 hospitals in 4 counties and 1 city, dozens of different times. And so you have this broken chain of treatment. So imagine a medical system where physicians and treatment providers can't rely on prior history to treat this person. It's beyond comprehension. And the other thing that happens is it stifles accountability. And when I tell you that people hide behind HIPAA, I'm a 14-year educated man that has been in every situation possible. And it's only the grace of God, and I think there's a plan out there for my wife and I to somehow make a difference, that we're sitting here and that our son hasn't killed himself. He is far more likely to kill himself than he is to live the rest of his life with his illness. And so what we find is that once he gets in the hospital, treatment can be delayed or not done at all. And I want to cite this example. Our son escaped from a mental health facility that was locked. HIPAA was thrown out the window. The hospital was calling us. The police were calling us. They were trying to pry into his bank records. Every privacy violation you can imagine was enacted to try to do this manhunt for my son. They found him 4 days later. They dragged him into a state hospital in shackles, so we can talk about stigma later. Once he was in there, he verbally assaulted the administrative hearing judge. He was put on suicide watch. He was completely out of it. And when the time came for his hearing to see whether he should receive treatment, we were precluded from participating because of HIPAA. And that panel looked me in the eye afterwards and said, we can't do it. Our hands are tied. 2 days later, a staff member was killed in his wing. We don't even want to know what happened, but this is what did happen. He was 1 year in that facility. The abuse, the things that happened to him in that hospital, and they never, ever let us in. When he was 18, they couldn't live without us. When he became 18, we were the enemy. We might as well have been strangers on the street. We have doctors who have shared with us behind the scenes some things that they knew they were going to get in trouble with. They've told us we're going to lose our jobs, but we have to tell you. We were members of our community, and people know us. So people took chances. But when we got outside of our community, there were no chances being taken, and we were left out. The other thing that happens is, imagine somebody who's mentally ill being discharged back into real society. Even under the best plans with families being involved, it's a very difficult process. But take a look at someone who's not part of a discharge plan that includes his support network. Our son has been released and sent on buses, and we haven't found him for weeks, wondering if he's dead. HIPAA empowers homelessness. Our son has been gone. No money, no clothes that are adequate, no money, nothing. Gone. We look around in shelters, gone. We say, why didn't you tell us? We can't. HIPAA precludes that. And we say, well, we thought, and then this whole idea, this notion that they have to tell us if it's a threat to us, well, they're not supposed to let him out if they're a threat. So they've already decided it's not a threat, so they won't let us do it. So we search for him. The shelters can't tell that they're there. And then the next thing that happens is this person who's been released, you don't want this person released like this. No support, isolated, in fear, frustrated, angry, and we're his first target, right? We're the first target. And so people are being released every day without discharge plans involving the family, and they have no way to transition back into life. And you don't want that. You don't want somebody that has psychosis as a symptom that pops up. And by the way, this idea of anticipating and predicting when imminent danger is coming, I just fought in the state of Maryland for 4 months to try to get that across. Not one person on this planet can predict the tipping point of someone with a severe mental illness. You can't do it. So what you try to do is you rely on who? You rely on the people closest to that person. And who is that? It's the family, but the family can't do it. We can't give recent history to the next hospital or doctor because we can't get it. So what's worse is, as each year goes by, we have less ability to help. So this idea that we're going to provide information to the hospital, it doesn't work. And it's scary. So in closing, I would like to say that HIPAA has a lot of gaping holes in it. This is the biggest. But if there's ways to beat HIPAA, we seek to find it, which is bad. Our son and other people's sons and parents deserve the right to be collaborative and informed so that they're safe, and their child is safe. Thank you.
Thank you, Mr. Kelly. Ms. Thomas, you're recognized for 5 minutes. Thank you.
First of all, I'd like to thank Congressman Braley for asking me to come to Washington to tell my story, and I'd like to thank Chairman Murphy and Representative DeGette for holding this hearing today on this very important subject. My name is Jan Thomas, and the story I have to tell is a nightmare that could have been prevented. My life has not been the same since this tragedy occurred, and it changed the lives of my entire family and my community. On June 24, 2009, what started out as a normal, beautiful spring morning ended up being the beginning of a nightmare. Shortly before 8 a.m., a 24-year-old former student, Mark Becker, walked into our high school weight room and in front of 22 young high school students emptied his gun at close range into my husband, Ed. Ed did not survive his injuries, and he died on the way to the hospital. He was only 58 years old, and he had taught and coached for 36 years. In one quick moment, so many lives were impacted forever. Our family lost a son, husband, father, grandfather, and brother, whom we all love very much. The students in the weight room that day, along with our extended community, lost a mentor, friend, teacher, and a coach. They lost their sense of confidence and security, and the horror of that day will be with them forever. Innocent youngsters, including our own young grandsons, suddenly realized that the world has a dark side. They were taught a horrible but truthful lesson that day. Bad things do happen to good people for no explainable reason, even when they think they're safe. Our grandsons were robbed of the deep love of their grandpa, and they will miss all the experiences they could have had with him. My sons lost their father, whom they love very much, and I lost my husband and my life partner on that day, and we miss him every day. But the real tragedy of that day is the fact that this all could have been prevented. Only 4 days before Ed was murdered, this same young man rammed his car into the garage of an acquaintance and tried to break his way into the home with a baseball bat. When police arrived, he fled in his car, leading the law enforcement on a high-speed chase. When the police finally apprehended him, he was taken to an area hospital for psychological evaluation. Less than 24 hours before my husband died, Mark decided he didn't want to stay at the hospital. And so, not following the advice of his doctor, Mark was dismissed. No one knew. Law enforcement was not notified, even though they had requested that the hospital let them know when he was going to be dismissed. The hospital's justification for not notifying the law enforcement prior to his release was that HIPAA prevented this disclosure. Even his parents did not know until Mark himself called them later that evening. No one knew that Mark had been released, but Mark's privacy had been protected. During the investigation into the murder, it was revealed to us that Mark had feelings of animosity and resentment toward Ed. We didn't know that. If Mark had come to my home that morning and asked where Ed was, I would have innocently sent Ed's killer directly to him and Ed to his grave. And what a horror to think that I may have had to live with that. Once again, Mark's privacy had been protected. Adults with severe mental illnesses are not always able to make good choices for themselves concerning their treatment or their actions. They may need help of a family member or other responsible parties to be sure they receive required treatment. They may need outsiders to keep them and others out of harm's way. But due to HIPAA, even Mark's parents were unable to get requested information or help make decisions for his treatment. So I would ask you, is the privacy of one individual more sacred than a life? Is it more important than the welfare of our general public? Is it more important than allowing our law enforcement to know when a potentially dangerous offender is being released back into the very community that they risk their lives every day to protect? Ed was an inspiration to so many in our community, and most importantly, he was a loving son, father, grandfather, and brother. I urge Congress to update this law so we can prevent further tragedies like this one. Thank you.
Thank you, Ms. Thomas. Ms. McGraw, we are recognized for 5 minutes.
Thank you very much. I really appreciate this opportunity, and I want to thank the chairman and the subcommittee for focusing on these issues, which are clearly very critical. I direct the Health Privacy Project at an organization called the Center for Democracy and Technology, which is a nonprofit public interest and advocacy organization that works on behalf of consumers. We like to think of privacy as playing an incredibly important role in making sure that people who are suffering from stigmatizing conditions like mental illness will actually get into treatment. Many people express, 1 out of 6 in surveys consistently, that if they didn't have some guarantees of confidentiality, that they would not seek treatment. And that's the reason why we have privacy laws. They're not aimed at trying to create obstacles for people necessarily, but to create the kind of treatment environment that people with stigmatizing conditions will want to be in. Having said that, they are not absolute. They have lots of exceptions, and the previous panel talked about them. Some of the members of this panel have talked about them as well, that allow for the notification of persons in the event of a serious and imminent threat, and also notification of family members, except in cases where there's been an objection by a patient who has the right to object. So in this case, it would be either an adult or an emancipated minor, or in some states that allow minors to consent for treatment on their own and to be able to control their privacy rights. In that case, the minor would hold the right. If that objection has not occurred, or you're not dealing with someone who's incapacitated, HIPAA does provide for the ability for providers to share information with family members, with close friends, or with people that the patient designates. Having said that, I think it's abundantly clear from the testimony that we've heard today that HIPAA is badly mangled in terms of how people interpret it. And using it frequently as a shield not to disclose information, or because they fear liability, which frankly is not anywhere in HIPAA. And it's what's incredibly frustrating to me when I hear these stories, and I'm sure it's frustrating for all of you too, is that, HIPAA doesn't say you can't disclose. So for people to blame this on HIPAA is just incredibly frustrating, because in fact HIPAA does allow those disclosures in those cases, and where the disconnect is happening is just incredibly frustrating to me. Again, I am a privacy advocate, but I believe in the reasons for these exceptions. We try to take a very balanced approach to these issues and understand the reason why those exceptions exist. And yet, for whatever reason, the myth that you can't disclose to family members, and again, the disclosures to family members are not bound by the potential for a serious and imminent threat. It is the case, though, that if an individual objects, again, if they have the competency and the power to object, then that would be the case where you couldn't disclose. But I would say more often than not, there's, again, the experiences of the folks at this table notwithstanding, people actually want their family involved in their care. I've had people say to me, my mother, my elderly mother who I'm caring for, I would like to be able to have her doctor talk to me about her treatment, and yet that office is telling me that HIPAA will not allow it to happen. And that's so untrue, and so I am incredibly sympathetic to the frustration of people who are told that HIPAA requires something that it doesn't. And I'm trying to figure out what we can do better in terms of educating folks about what HIPAA does and what it doesn't do, because it sounds to me like too many people are hiding behind it in circumstances where there are clear exceptions that would allow for that information to be shared. Some of the testimony of Director Rodriguez in the first panel, frankly, there was a lot more. I had a lot greater understanding of the exception for family members than I did before the hearing. And so that suggests to me that this guidance, which I think is good, It's not the letter that everyone's been talking about, because the letter deals with serious and an imminent threat. This is guidance about what can be shared with family members, because often patients, in fact, want the information to be shared with one or more of their family members or a close friend who's helping to care for them, and yet it doesn't happen. And it could be made more clear, frankly. And we could find better ways of disseminating this guidance. I mean, I know where it is on the website, but there's probably lots of folks who can't find it, who aren't aware that it exists, and particularly when faced with a person and a healthcare facility telling them, which is probably something that they unfortunately believe, that HIPAA won't allow that information to be shared, when in fact it does. I'm happy to answer any questions, and I appreciate the opportunity.
Thank you very much. We thank all the panelists. I want to also say here that our hearts go out to the families of Mr. Wolf, Mr. Kelly, and Ms. Thomas. These are sad tragedies, and Mr. Kelly, that you're still dealing with here. We're going to recognize each person for 5 minutes. I just want to make it clear, Ms. Levine, you stated you had some opinions in your testimony. You're not a licensed provider, am I correct?
No. We are.
And you're not a practicing therapist in this field?
Not at all.
Okay. This is very important for the record, because on page 10 of your written testimony, you said that doctors don't want to share information and is a quote, a convenience excuse not to talk to families or listen to what they know about a patient, unquote. You went on to say it's, quote, easier to avoid difficult conversations about prognosis and treatment options, unquote. Dr. Martini, is that true? The doctors don't want to know this? They don't want to know this information? They don't want to talk to families because it's difficult?
No, I think that the vast majority of physicians that I work with are very interested in sharing that information and very much want, I think, to involve families in care. I mean, I think we know that, particularly for psychiatric patients, that their prognosis is improved. I mean, one of the ways I look at it is I see a patient perhaps at the most an hour a week, and the families are dealing with these individuals on an ongoing basis. And I think any recommendation that I make as a clinician is much more likely to be successful if I'm able to get the support of the family.
Mr. Wolf, Ms. Kelly, and Ms. Thomas, and Mr. Kelly, just real briefly, just in a word or two, because I don't have a lot of time. Also, from your standpoint, because you have also talked to providers about these cases, do you think in these cases the providers did not want to talk to you, or they did, but they felt they could not because of their interpretation of the law? Mr. Wolf?
Yes, my family physician told me later that he did want to disclose it, but he felt that he was under the obligation of the HIPAA rules not to disclose it.
Mr. Kelly?
In 14 years, I've never encountered a situation where a treatment provider did not want to disclose it. In fact, they went out on a limb and would secretly tell us. No, I've never had that.
Ms. Thomas?
I can only speak for what law enforcement told me and also what Mark's parents have told me about, and they all had difficulty getting information.
Thank you. Mr. Wolf, Mr. Kelly, you heard from Mr. Rodriguez from the Office of Civil Rights that the law, sounds like he's saying that the law is adequate, and the problem is that providers aren't really aware of the law and are unjustifiably worried about lawsuits, perhaps even hospital administrators who pressure staff not to disclose information or they'll be fired. Do you think that is true, that it's adequate the way it's, both the way the law is worded and in terms of the way information gets out to providers? Mr. Wolf?
I don't think it is adequate as far as getting out to the providers, because both in my son's case with the rehab situation as well as my family care physician, both of them after Justin deceased, I confronted them and they both told me that they definitely would have said something with regard to informing me. However, again, with Justin signing the HIPAA disclosure, they were not permitted to. So I do feel that they did have an obligation. They knew that it was a life-threatening situation with the use of heroin, but they were obliged to follow the HIPAA regulations.
Thank you. Mr. Kelly?
In all due respect, I fear there's a significant detachment from reality here. Not with you, sir, but with Mr. Rodriguez. It's underlined, unless the patient objects. And someone that's severely mentally ill universally wants to object. They don't believe they're ill. So that gets thrown out the window. And the fact is that we need to have exceptions for the severely mentally ill. It's just plain and simple.
Ms. Thomas?
I can speak on behalf of the fact that I am a volunteer EMT for our community, and the threat of lawsuit, and it prevents us even from feeling like we're able to tell direct family members conditions of patients that we transport. So either it's misunderstanding, but that's what's emphasized to us in our training.
Thank you. Ms. Vergara, you, in your written statement, you said that 17%, or about 38 million, say they would withhold information from healthcare providers due to worries about how medical information may be disclosed. You were citing a study.
Yeah.
My understanding is that study was on general health issues, not mental health or severe mental illness. Am I correct?
No, that's right. In the time that I had to prepare for this testimony, I looked for some more specific statistics on, persons being held back from seeking treatment for mental health, and I didn't have enough time to find something directly on point. I did find something on the National Alliance on Mental Illness website that talked about how about 2/3 of people with mental illness do not seek treatment for a number of reasons, though: lack of knowledge, fear of disclosure.
Yeah, I appreciate that, and I hope if you find some other studies.
Yeah, I'd be happy to keep looking at.
I might also say that
ran out of time.
We have folks here also saying that doctors didn't disclose information, and people are over-interpreting the law and not disclosing. And you're saying that perhaps patients are also over-interpreting that it would be disclosed. Let me ask you this, because you gave something very important. You said it's badly mangled. I think that was your words. What can be done to clarify the law? Do we need legislative language? Do we need to cite case law? Do we need some clarification from the Office of Civil Rights? More public education? What do we need here?
Yeah, well, so the badly mangled part was the reference to the fact that we've had all this testimony about what's really in HIPAA, and yet people are being told, in fact, that HIPAA is something that it's not, and with significant consequences. Got more guidance and better ways of disseminating it, so it's not, you don't have to look really hard for it on a website. Absolutely is the first step that we should be pursuing here, and ideally that could be done in conjunction with the professional societies who have more effective mechanisms for doing outreach to their members. Having read this guidance, I'm like, well, it's clear, but it could be made more clear, more examples. In this circumstance, you can do X. In this circumstance,
Thank you. We'll look forward to getting your specific recommendation on that too. Mr. Braley, 5 minutes.
Thank you, and I should also note, Mr. Chairman, that Ed Thomas's sister, Connie Flaherty, is also in the audience today. This has impacted her as well. And Jan, I think some of the things that your testimony brought out is there's this misperception that the issues we've been talking about today are unique to large urban areas with a higher concentration of people who are seeking treatment for severe mental illness. Parkersburg is a town of 2,000 people. 5 years ago, this May, it was nearly destroyed by an F5 tornado, and your husband, Ed, was one of those people in the town who rallied people to come back, put the community back together. And one of the other things that I think is so important about your story is that Mark Becker is someone you and Ed knew very well.
Exactly, yes. He was a member of our community. We've known him his entire life and his parents. And I know their frustration in getting him treatment, but there again, I agree with what they're saying. When it comes to severely mentally ill people, you can't classify them with someone that has cancer or hepatitis or those kinds of things because their thinking is just not rational. And I think there maybe needs to be some exceptions to those rules there.
Well, and one of the other things that we know is that from the stories that have come out, you and Ed went to the same church as Mark Becker's parents, so it wasn't like this was a stranger in your family. And I know that the Becker family has expressed some of the exact same frustrations as parents that we've heard from the other panelists in trying to get Mark the help he needed so that he could put his life back together. And I think that's one of the most disturbing things about this topic, is these are stories we hear over and over and over again, and it points to a breakdown in our ability to get people who need it the services that they need in communities all over this country. But one of the things that I'm really interested in is how this particular tragedy in your life has changed how people in your community think about the problems we've been talking about.
Well, it's hard to speak for other people, but I do think I think there needs to be more awareness of mental health. I think this needs to be expanded on quite a bit. I don't think there's enough resources out there for people. I think the fact that no one knew that Mark was released in a threat was very frustrating to people. I mean, there were a lot of victims involved. It wasn't just our family. Those young kids were 14 and 15 years old that witnessed their coach getting shot down at close range in cold blood, and it's all could have been prevented. And I think that's a big frustration for a lot of people. He was not able to get out of harm's way, and he was loose on the streets just because he wanted to be.
Well, I think one of the other things this points to is I lived with somebody with a severe mental illness 40 years ago, and I remember the stigma attached to mental illness then. And I think we'd like to think that we've come a long ways as a society in dealing with mental illness as something that is just as real and impacts people's lives as much as other diseases. But I think the reality is that there's still a lot of stigma attached to it. We like to avoid having these conversations unless it's impacting us personally. So I want to thank all the panelists for having the courage to come share your stories. I know that's been an incredible challenge for all of you. And one of the things that I talked about earlier is this challenge that family members have with adult children of being able to have a role in making decisions about their care when there are sometimes obstacles. And Dr. Martini, you talked about this a little bit, and one of the questions I'd raised early is whether this risk to self or others standard is still a viable way of getting patients the help they need for a truly effective treatment. You gave examples of both sides of the story. One where a family's intervention was counterproductive, one where the need for family intervention was not provided that could have been in the best interest of the patient. So how do we resolve this?
Well, I think Congressman, what I would like to do is think about what you last referred to. What is in the best interest of the patient? What do we think is going to help the patient most, help them in their recovery? I understand that there are issues around the release of information and confidentiality, and I understand that patients are sensitive about that. But what we're talking about is not a release of information generally out to the community. What we're talking about is thinking about particular cases, looking at those cases on a more individual basis, and deciding if this patient is going to do well, what's going to be necessary, what kind of information needs to be shared. Should that information be shared with family members? Are they an asset in this particular case, and can they help out this individual? Would it be a good idea to share the information with the primary care physician in their community, who quite often coordinates care in a variety of ways? That's also an asset that quite often is not part of the process in some ways because the patients are reluctant to have any local connection, know much about what's going on with them.
Thank you.
So it's what's in the interest of the patient, I think.
Thank you. And Mr. Braley, that article you referenced before for Sports Illustrated, would you submit that for the binder so it's in the record as well?
I would be happy to.
It's got to be tragic. For all the reasons someone would be on the cover of Sports Illustrated, that's got to be the saddest. It is. Thank you. I now recognize for 5 minutes, gentleman from Virginia, Mr. Griffith.
Mr. Chairman, if I could pass this time, I'd appreciate that.
We'll do that. I think go to Mr. Johnson for 5 minutes.
Thank you, Mr. Chairman. First of all, panel members, I'd like to reiterate thank you so much for being with us today and for your testimony. I know these are very tough testimonies to give, and our hearts go out to you. Ms. Levine, you suggest that healthcare workers sometimes use HIPAA as an excuse not to share information, and not simply because they're afraid of fines or censors. Why else would someone withhold information from inquiring family members?
Well, because the role of a family member in the care of someone who is, as I said, most of my experience is with older adults. Although I personally was the family caregiver for my late husband for 17 years. He had a traumatic brain injury and was quadriplegic. So I have my own experiences with this system. But family members ask hard questions. They want to know a lot of information about why did this happen, what could I expect, why are you giving this medication when it's on the list that says this is contraindicated. I can't tell you, and this is not to disparage the nursing profession because they're fabulous, but I've had so many nurses say to me, "Are you trying to tell me how to do my job?" Okay, yeah, I think I am, because my husband should not have this medication and that medication together. So there's a kind of, tell you how many physicians, nurses have said to me, family members, they're pests, they're nuisances, and they are. I mean, I'm not denying that, because they ask the hard questions. The patient in the bed is in pain or is sedated, not going to be a trouble.
Okay.
So I think it's a truth universally acknowledged that family members are important on the day of discharge. Get them home, but not necessarily in the course of a hospitalization. But I really think that the HIPAA scare, and I'm now concerned that there's now going to be a high-tech scare, because I'm already getting emails from vendors saying, we're going to protect you from these horrible audits that are going to happen, and if only you hire us, you'll be safe.
Oh, yeah, every time there's a new government regulation, an industry crops up around providing services.
It's not one thing, it's that things support each other. That is my feeling.
Let me quickly go to several other questions. One of your recommendations has been for OCR to reinforce to healthcare providers the provision in HIPAA that permits disclosure of relevant information, protected health information, to family caregivers or others who are going to be responsible for providing, managing, or paying for a patient's care. How do you suggest OCR go about doing this?
Well, I think throughout, and I agree that the website is one way, but not the best way. I think that there can be involving the medical professions, involving the people, the risk managers who are doing a lot of the training, involving the leaders and saying, this is not good patient care. We're concerned about hospital readmissions. One of the reasons people come back from the hospital to the hospital within 30 days and cost Medicare tons of money is that the family members who are responsible for that care don't know what to do.
Okay.
So they bring them back to.
Do you have recommendations for CMS as well?
Yes, CMS should definitely encourage as part of the conditions of participation in Medicare and Medicaid, to make sure that the training, that they are responsible, accountable for training the hospitals and nursing homes to train their staff in a balanced way. And I say one more thing which I didn't get a chance to say.
Quickly, I'm running out of time, but go ahead.
Just quickly. We ask, when we encounter through our contacts with providers, patients who object to having a family member involved. It has nothing to do with privacy. It has to do with, I don't want to worry my daughter. I don't want her to have her had any responsibilities. It's not for privacy.
Okay. Mr. Kelly, you've observed that a clear culture of fear pervaded one of the facilities your son was admitted to. How does this culture of fear impact decision-making by those health care workers and facilities tasked with taking care of your son?
And it's more than one hospital, sir, but essentially we're not in a position to prevent horrific things from happening, and we've had some candid discussions with staff and doctors in multiple hospitals where they'll acknowledge that they use the word our hands are tied due to the HIPAA privacy rules. And so we try to go further and emphasize the inability of the patient to take care of themselves and make good decisions, and it doesn't faze them. So what happens is the patient gets mistreated, actually. And so our son has come home and been on the wrong medication and has been in horrible conditions. So it's pervasive. It's not just isolated to one situation.
Thank you. Mr. Chairman, I yield back.
Thank you. Gentleman's time has expired. Ms. DeGette for 5 minutes.
Thank you very much, Mr. Chairman, and I'd like the panel to know that I've read all of your testimony, even though I wasn't here to hear you say it. And for those of you who have lost loved ones, my deepest condolences. I know, as I said in my opening statement, I know how difficult it is to have a child with a severe illness. My child has a physical illness, not a mental illness, and she's now a freshman at college. So I know what you've been dealing with in terms of, and Dr. Martini, I know what you were talking about in your testimony too, of the parents paying the college, the college tuition. Parents obviously love the child and are deeply concerned. and yet the child is over 18 and they are wanting to become independent, and they do have privacy issues. It's a really hard balance, especially when you're dealing with some of these mental illnesses, which, as we learned in our previous briefings in this panel from professionals, bipolar disease manifests, which is at the root of some of the violence, most notably suicides, that evidences itself in young men between the ages of 18 and 25, and in young women at a slightly older age. But this is right the age where they're becoming independent from their families, and most of the time they're over 18. So it's a hard balance, because on the one hand, it's like Ms. McGraw was talking about, you want these young people to not feel the stigma so that they will get medical treatment. And on the other hand, as parents, we want to know if they're at risk to themselves or to others. And so it's a balance. Dr. Martini, something you said just a moment ago really struck me, which is, in trying to grapple with this issue, you said that we need to look at the individual, the doctor. We need to rely on the doctors to look at the individual cases and to see if this is a situation where having parental involvement or involvement of another responsible adult would be appropriate to let them know. And I guess I agree with that, but I guess I also, in listening to the testimony of the last panel, would that's exactly what they were saying. What they were saying is, in their interpretation of HIPAA, that's exactly what medical providers are allowed to do. And so I think what we need to do is we need to providers need to understand what their abilities are under HIPAA. Wouldn't you agree with that?
I mean, I think that's a very important part. I think educating providers about HIPAA also in a way that makes it seem like this is more of a collaboration, that there is information to be gained. I mean, for example, the state of Tennessee has created a review panel of physicians that can look at cases and can override aspects of HIPAA if that panel, and it's an objective panel, decides that this particular situation is worthy of that. And I think those kinds of initiatives where HIPAA is seen as not simply a government regulation,
mandate, yeah,
but as a process, as something that they can participate in, I think the outcome would be better.
I agree with that, and if we still have our HHS witnesses here, yes, we do. Some of them is I think we should also have our federal agencies work with the colleges, because a lot of these problems seem to come with the colleges trying to balance the important privacy protections for their students and also letting parents know. And again, I think they would have some leeway, but we would have to work with them to let them know that.
I think it's a very good point, and
Okay.
I think there would also need to be some help for them, because coordinating the mental health care for students some thousands of miles away would be a challenge.
And this goes to the last thing I want to talk about, because it's not just the HIPAA issues, it's also access to treatment. And I think some of you have probably seen this in your communities. I was actually at the eye doctor, and the assistant came in, and she said she had a 19-year-old son diagnosed with bipolar, and he had become violent. He actually put himself into a 72-hour hold, and then he was released. And he actually, involved his parents, and they were involved with it. They couldn't find any mental health treatment for this kid in Denver, Colorado. And this is another issue as well, as, once you diagnose this, you've got to be able to find treatment. I think, Doctor, you'd probably agree with that.
Absolutely. I think workforce is a big issue, certainly in pediatric mental health services.
Yes.
And also, I think, I kind of alluded to this a little bit, we also need to work on access through primary care. I mean, the thing to remember is that a majority of the mental health problems are actually treated by local physicians in the community, and we need to work with them, we need to help them, we need to educate them so that access begins locally.
Thank you. Thank you, Mr. Chairman.
Thank you. Dan recognized, gentleman from Virginia, Mr. Griffith, for 5 minutes.
Thank you, Mr. Chairman. Appreciate your patience. Let me follow up on that. I think, Dr. Martini, you were talking about local health professionals being involved and trying to make sure people get treatment. Is it your opinion, or what are your thoughts? Can HIPAA also stand in the way of proper communications between, for example, a treating mental health professional and a patient's general care physician?
I think that there have been cases that I've worked on where the family, the patient, does not want the local physician to know about the extent of the psychiatric problems, in part because the local physician is in the community, knows a great many people. I think I think a good bit of that anxiety is misplaced on the part of the patient, but I can understand it. I also think that what we need to do is we need to work with these local clinicians and physicians to involve them more in mental health care, to educate them, to make them part of the mental health system, so that families recognize that the help that they provide is going to be in the patient's and the family's best interest.
Because one of my concerns that we heard from a previous hearing was it takes, or informal hearing, but it took 18 months for the average person with a mental health problem to, get to see a mental health professional, and that's of concern and something that we need to address. But it would seem to me that your primary care physician might be in a position to shorten that time period just by making the referrals or by saying this is not such a big deal. And when it is a trusted family physician, a lot of times they can be helpful in that regard. Also, in following up, if the professional is not in the immediate community, I represent a rural area, so the mental health professional may be, the next community over, 30, 40, 50, 60 miles, maybe more. And if they can then communicate with the local healthcare provider, it does create some benefits there. From the perspective of the patient, why do you think such free communication between healthcare providers is important?
I think that I think on the part of the patient, what it will allow them to do, as you were pointing out, is receive services, I think, more efficiently. I think that the local practitioners understand the community, understand what's available in the community, what's available not simply from the standpoint of medical services and mental health services, but also within the community, within schools. They're familiar with that. I think that what we need to do as mental health professionals is we need to work with them to teach them what they can do, to get them comfortable with what they can do in their practices, and also to teach them when they should refer to us. And then, as part of that, we need to be available. We need to make ourselves available, and that's a big question. We do need to increase the size of our workforce, but also we need to do this in a much more efficient and effective way.
Thank you very much. Ms. McGraw, I noted in your testimony that the fear of liability for violating HIPAA's provisions coupled with misunderstanding of its provisions can be a recipe for not sharing. Mm-hmm. And I'm just wondering if you're familiar with, and I hate to ask Ms. Thomas, but I would ask, are you familiar with suits that go the other way, where permission could have been granted? I mean, in Ms. Thomas's case, the police asked to be notified. The police had made a determination he was dangerous to the community. They didn't want him out on the streets. The hospital then used HIPAA as a shield to say, oh, well, we couldn't tell the police anything. So I'm just wondering if you, Ms. McGraw, have heard of any suits, and Ms. Thomas, did you all even consider suing them for letting this dangerous person back out on the streets when HIPAA would have allowed it?
So I can tell you that HIPAA does not actually have any provisions that enable anyone to sue on enforcement of it. So either a patient in terms of privacy rights or someone else in terms of sort of over-interpretation. Keep in mind also that HIPAA's allowance of disclosures for these reasons that we've talked about is permissive. It still relies on the judgment of healthcare providers to make the judgment call about what's in the best interest of the patient. Having said that, we need to keep in mind that HIPAA's the floor and that there are state laws that may provide greater protections, may have medical privacy statutes that could be used to impose liability in those circumstances. But I certainly have never heard of anybody being sued for not releasing information, except in the case of information that a patient asks for that is about them. Because you are required under HIPAA to disclose that information. You can be held accountable under HIPAA for not doing so.
I guess my concern is that, and I was a practicing attorney for a lot of years, but my concern is that that's one of the ways people like to hate lawyers, and I understand that, but that's one of the ways you sometimes get rectification in some of these cases. Not that the money is important, it can't bring anybody back, but it may keep somebody from making that mistake again. I mean, here we had an individual, in your case, Ms. Thomas, who the police bring in. He's just run his car into the back of a garage. He's clearly either a danger to himself or to others. They bring him in. They want psychological evaluation because he's a threat to somebody, and the hospital just lets him walk out even though the police asked for notification. I can't think of anything else that would. I mean, to me, that's the classic definition of negligence. And I'm very sorry. And
no, it's
if you
fine.
want to answer, you can. But
it was considered as far as looking into a lawsuit. However, we were unable to get Mark's records due to HIPAA, and we just decided that it probably wouldn't be. It really wasn't going to benefit anybody at that point in time to proceed with a lawsuit.
And I respect that decision.
Gentleman's time's expired.
Thank you. I appreciate it, Mr. Chairman. I yield back.
Recognize Mr. Schakowsky for 5 minutes.
Thank you, Mr. Chairman. First of all, I just want to say that I hope in future hearings and other events that we will include testimony and participation from the patient community. And I know that there's some. I know there's a discussion right now about including testimony.
We are not permitted to have any outbursts, and I would ask that members not say things that might also provoke some outbursts. So I ask the folks to be, no, I've just rolled down, let's continue on. Go ahead, Mr.
Okay, I know there's some discussion about including written testimony, highly footnoted, into the record, and I would certainly recommend that be done without much ado. I wanted to and let me thank especially the family members who came here with your stories. I know it's got to be very, very hard to do, and it's much appreciated. So here, I want to understand the examples a couple of the examples that you gave. You had a former patient with a mild form of autism, and eventually his parents went to court against his wishes because they said their son could not care for himself and must remain dependent. And you conclude, unfortunately, the subsequent ruling in their favor was counter to our goals of psychiatric treatment and derailed his progress in therapy. So are you saying that that was a bad decision, that the son should have been able to do what he wanted to do?
No, what I was saying was that because the son would not allow his parents to be involved in his affairs, nor would he let them to be involved in therapy. So I couldn't incorporate them into any of the programming that I was trying to organize, any of the treatment that I was trying to organize, couldn't involve them in the medications that he was prescribed. And they had serious concerns about how he was going to function. Because we couldn't negotiate that, because he continued to refuse to allow them to participate, this was the only recourse that they had. It went counter to our therapy because the purpose of the therapy for me was to make him more functional. That my goal was...
I understand that, but what would, at the point that you're saying, if they had been involved earlier, and I understand that, but at the point of someone making a decision, an adult making a decision about what they want to do, is there, I'm trying to understand what a better outcome might have been, and could it have been done without having to go to court?
I think that's one of the reasons I put it in there, is because I was searching for another way to have a better outcome without having to go to court. If there was a mechanism, for example, similar to the thing I mentioned in Tennessee, where there was an opportunity to appeal or to present a case in front of a review board involved in HIPAA, to say this is what's going on in this case, I think it is in this individual's best interest to have the parents involved, to have them actively participate, because I think it's more likely that this individual is going to be successful. His treatment is going to be successful, and his life, I think, is going to be less traumatized if you have an opportunity to do that, and there's a means to modify what's happening with the HIPAA regulations in these particular cases. I think that it would be an advantage not just for the family but also for the patient.
So you asked the question, if there is a bias in these situations, should it be toward parental involvement rather than away from it? what do you conclude?
Pardon me?
What do you conclude? If there is a bias in these situations, should it be toward parental involvement rather than away from it?
I think that if there's a bias in a situation, you know, as a child and adolescent psychiatrist, my bias has been to involve families. We involve families as often as possible in treatment, and I think that for a variety of reasons, and I think if there is going to be a bias in that situation, my recommendation would be that it be toward family involvement, particularly if there are no specific reasons within that family, if there are no contraindications within the family, nothing that would adversely affect the patient.
Just wondering, I mean, and I'm not weighing in on either side, but I think there are people in the independent living community that would feel that a young adult with autism, that there may be some better ways for that individual to live in the community with support, help, etc., rather than, as you use the word, dependent at home. Do you see that as part of the negotiation that might involve everyone?
Absolutely. I mean, I think in this particular case, the goal for this patient was greater independence. What the hope was in treatment was that he would be able to manage his affairs, that the level of anxiety that he felt in new situations would go down, that we would increase the capabilities that he had to manage his medications. But the sense was that having his parents involved, I think, would have expedited that process.
Thank you.
Thank you. Shelley's time is expired. Ms. Elmers, 5 minutes.
Thank you, Mr. Chairman. And I would also like to say to the panel, thank you so much. And I'm going to get emotional for coming and sharing your stories, because this is the only way we're going to change anything in mental health. And I know how difficult it is for you to come forward, but I can just say how much we appreciate your input so that we can make the right decisions moving forward. With that, I would like to start, Ms. McGraw. Thank you for your comments to my colleague. You know, one of the areas, again, as a nurse, and Ms. Levine, I completely I associate myself with your statements, because I think sometimes it's easier to just give a blanket, you know, hey, you don't know what you're talking about. You are the family member. Anyone who knows better for your family is you. So unfortunately, that's one of the downfalls of nursing, is sometimes we share our opinions a little too openly. But I am concerned about the misconception of lawsuits, because as we know, there are so many frivolous malpractice lawsuits out there, and that this is one of those gray areas where healthcare professionals do not feel that they are protected, and certainly HIPAA violations can be weighed against them, but yet at the same time, as far as malpractice, that is not necessarily an avenue that would be taken. And am I correct with your testimony?
Yeah, well, certainly there's nothing in HIPAA that would enable someone to be sued. You know, again, to the extent that you've seen sort of any lawsuits in this space around privacy violations, they are filed under state law provisions. Mm-hmm. And in terms of, I don't do malpractice work, but again, if you're facing a malpractice lawsuit, that's a state law action.
Perfect. Thank you. And Mr. Wolf, I would like to ask you a few questions.
Thank you.
With your situation, especially, and as sensitive as it is, and again, I thank you for being brave and sharing that with us. I read over your testimony to find that you were in a situation where you knew what was happening to your son. You knew that there was a drug addiction. And because of that behavior on his part, with the ease, the manipulation that they do so well,
right,
he was able to manipulate and then kind of get his way.
Yes.
And then you were able to get him into a treatment facility, but then you were told that they could not share information with you because of HIPAA, correct?
Exactly. And the manipulation and the lying that goes along with addiction, from what I have learned from my son, and from others that since this has happened, was just to give you one quick example. I wanted him to go into an inpatient treatment program immediately. And he said to me, Dad, I don't want to go into an inpatient treatment because I don't want to start using heroin or crack cocaine. And I, as a parent, had to make the decision what to do. Mm-hmm. And I did my research, and I did hear that people do smuggle in heroin and crack cocaine, and there are a lot of other users than Percocet usage, which is what he had indicated that he was doing to the family, not letting us know that he was doing the heroin. So therefore, the lies and manipulation, unfortunately, we sent him to an outpatient, which he said he would agree to go to. And when I tried to confront the outpatient counselor, for the first couple of weeks, I was denied any access to any records or be told why he was there.
And that unfortunately is a story that we continue to hear. And I do agree with you. I do think that there are some changes that need to be made. More clarifications, I think, than anything, so that both healthcare professionals, family members, and patients can all understand a little better what can be shared and what cannot. So I thank you.
Thank you.
Dr. Martini, I have just about 30 seconds left, but I do want to say just very recently I was at the Partnership for Children in Cumberland County, North Carolina. I represent in the 2nd District of North Carolina. We had a lengthy discussion about mental illness, especially in relation to children. I have a very good friend whose son is autistic and now is starting to show signs of depression and some beginning signs of mental illness. They're having an incredibly difficult time trying to find the correct physician for him because of his autism that had already been diagnosed. Quickly, could you just say a few words about that?
I think that the availability of services is a critical issue, I think, in child and adolescent psychiatry. We need to expand our workforce, not just among psychiatrists, but with all child mental health professionals. I think we also, as I alluded to before, we need to work with community physicians. We need to work with schools. There are ways to provide services for children locally that can be efficient and effective beyond simply going to a tertiary center.
Thank you so much. I appreciate the chairman giving me a few more seconds. Thank you.
Finally, time expired. Mr. Scalise is next, but I understand he's going to allow Dr. Cassidy to go first. Dr. Cassidy, you recognize for 5 minutes.
Thank you, Mr. Chairman, and thank you, Mr. Scalise. Every one of you, thank you for your note of reality. Ms. McGraw, clearly we are all concerned about privacy, and yet you can respect that there's a certain ambivalence that we must have. Or that's exhibited by this. So thank you all. Ms. Levine, the way that you said that the HIPAA law should be written in something that a patient understands, I put exclamation mark, exclamation mark, exclamation mark, because it is written to avoid liability, not to inform people of what their rights are. Now, thank you all. Dr. Martini, what a great name for a psychiatrist. That's okay, man.
I like it.
I asked Mr. Rodriguez a question, and you put here if you had a patient if lithium is still used for bipolar, and if the level is declining but the patient is still compensated, would you feel that current HIPAA laws would allow you to speak to the parent of someone who's emancipated by age or by law that, listen, if this lithium level goes any lower, they're going to have a psychotic break? This is not an immediate danger, but Mr. Rodriguez seemed to indicate that that would be permissible. Would you accept that in your practice that's what most psychiatrists or whomever are doing?
If the patient explicitly stated that he did not want that information shared, I think most psychiatrists would believe that if the patient was not an imminent danger to self or others, I think most psychiatrists would believe that they should not share that information.
Now, if their patient had a history of being non-compliant with lithium and having bipolar episodes and creating some of these terrible heart-rending stories occurring, would that change the calculus, or would it still be, no, we cannot do it?
I think that when I talk to colleagues of mine about that situation, if they're dealing with a patient that they know is dangerous, if they're non-compliant with their medications, they inform families and significant others, and they take the risk that they may be in violation of HIPAA because they believe that it's in the best interest of the patient.
Now it's interesting because you say they take the risk, and yet that is a perception, and yet some of what we've heard is that that should not be a risk. It should be kind of like, wow, don't worry, it's not a risk. that tells me that there's ambiguity even among people who are full-time professionals. Would you accept that?
Well, I think that that's true. I think that the problem is that it's that idea of waiting until imminent danger. A patient can be non-compliant on medication and for a period of time look pretty stable, and you know that eventually.
Now, just to, not to be rude, but we know that there going to be a pattern of episodes. And so we know, man, he's off his lithium. I see his level going down. Boom, it's going to happen again. Now, he doesn't pull a gun. He doesn't do anything terrible, but he does live under a bridge. He does leave his family. He does sell all his possessions and run down the street, whatever. In that, would there be ambiguity among your colleagues whether they are at risk?
I think that if, when they're seeing the patient, if the patient appears stable and is doing well, but they know they're non-compliant with their medications, understanding that mood disorders quite often are episodic, I think that there would be some concern if they told the family, but they understand that in many situations they need to do that because the patient has a history.
So again, there is a perception they're running a risk.
I think there is a perception that they're running a risk.
Now, Ms. McGraw, Mr. Kelly used the term I'm not quite sure how to pronounce, but I think we're all familiar with if we have a teenager. On the other hand, his is far more dramatic than that. A year of no insight. Now, this gentleman, his son, said that his parents could not know his history, and yet he had no insight. You are honest. You're not quite sure how to address that. But what would you suggest? By the way, I was also struck, as smart as you are, and you're an expert in privacy, you learned something from Mr. Rodriguez's testimony. I will tell you, an ER physician seeing 20 patients a night who is not in your specialty, not hearing this testimony, there is no way that ER physician, there's no way that she can actually be as facile with this information that we're demanding her to be. What suggestions would you have as regards, though, Mr. Kelly's son?
Well, so one of the things that we've had a lot of conversation about, and when I said that I learned something from Director Rodriguez this morning, was how the concept of incapacity plays in the capability to share information with family members, which is not contingent on serious or imminent risk, but circumstances under which a mental health professional can make a judgment about talking to a family member when they believe it's in the best interest of the patient, which is in circumstances when the patient's not around to object or in incapacity. And, you know, in sort of looking through the guidance that is right in front of me about the ability to talk to family members, the issue of this incapacity, which is in fact in the regulatory language, is not really explored in very much detail. So it does leave a lot of uncertainty on the part of providers about how how do they comply with that and what does that mean? And it certainly would be helpful to have the guidance explore that issue in a little more detail, in my opinion.
Thank you very much. I yield back, and thank you again, Mr. Scalise.
Thank you. Mr. Scalise, you're now recognized for 5 minutes.
Thank you. Thank you, Mr. Chairman, for having the hearing, and especially want to thank those family members who have been impacted by mental illness for coming here and sharing your stories with us. We had I thought, a real helpful forum back on March 5th where we had some other family members, including Pat Milan, who's from my district, whose son Matthew took his life, was being treated for mental illness. They actually thought they were making progress. They both, Pat and his wife Debbie, were trying to get information from the doctor, from the treatment centers, and were not able to get that information. And HIPAA was being thrown up as the reason that they couldn't get access. It turned out after the fact, unfortunately after Matthew took his life, that in his file he had actually authorized his parents to have access to information. And so it was just incredibly frustrating, angering, for us hearing this at the forum that we had, but especially to them as parents who were trying to get the right kind of help for their kids, for their son, and just couldn't get that access. And so when we hear these stories, and I know Ms. McGraw, you talked about it, Ms. Thomas, that people hiding behind HIPAA when it turns out that HIPAA really may not be the impediment, how do we get some clarity in HIPAA to remove this gray area, if it's even in fact gray, that's stopping vital information from being shared with family members, and even in cases where these patients want their parents to have that access, and yet it's being denied. If anybody from Dr. Martini and maybe go across, if we can try to figure out what is this disconnect, that's stopping this information from being shared when the law, by many people's own interpretation, doesn't preclude that information from being shared?
I think that the thing that's missing in these situations is a discussion of the clinical presentation, of looking at these cases on a much more individual basis and providing within the law some flexibility for whether it's appeal or whether it's involvement by clinicians, so that there is an opportunity for a psychiatrist, a psychologist to present the case to an objective body, to make a request for modifications in HIPAA in those particular situations. Again, thinking about what is in the patient's best interest, and to have that objective body rule on that process. I think somehow making it feel as though this is not simply the government telling people what to do, but it's the government giving people an opportunity to protect their rights, but also to ensure that patients get the best care possible.
Ms. Levine?
I think we need to start with medical education, nursing education, and all other kinds of education to have objective people presenting the rules of HIPAA, what is permissible, so forth, not the risk managers. I'm sorry if anybody here is a risk manager, but I think this perception of the legal liability, yes, anybody can sue anybody for anything, but the real risk is in the security of the electronic data. And that seems to have been ignored in all of this HIPAA scare. The Washington Post did a year.
And I apologize. I've only got a minute left, and I want to get the
so
floor
I
remainder.
think we need to do the education in an objective way, balanced way, and think about the patient's best interest, which
Thanks, Mr.
generally
Wolf.
include the family.
Yes, I just want to say that I feel that the parents, it's very important for parents to be apprised of what is happening with their children, even when they're legally emancipated. And I think that's important to be put into because of the Obamacare. Since we do take care of them till the age of 26 under our insurance, I would not have lost Justin if I was made aware of what he was going in for. So I think the parents have to be made aware we're the best caregivers with regard to our children, and there has to be an exception with regard to that.
Thanks. Mr. Kelly?
I'd like to ask that the committee start expanding the definition of a family member beyond a parent, because there's other members of the families that are in these roles. But quite frankly, change is hard, and I want to thank Ms. McGraw from the bottom of my heart, because it's taken so long to hear what she just said. And we need to change things, and sometimes you can't get change unless you change things. There's got to be a carve-out for the severely mentally ill, or this unless the patient objects clause will rule the world.
Thanks, Ms. Thomas.
I guess I would kind of agree with what he said. I think we need to be made more aware of what HIPAA actually does prohibit, and I do think there probably should be some special clauses there for the mentally ill.
Thanks, Ms. McGraw.
Yeah, lots more guidance, clear, understandable, disseminated to places that people can easily find it. Maybe even a hotline for questions.
Thank you, Mr. Chairman. Yield back. Balance my time.
Gentleman's time has expired. At this point, we finished the testimony. I just want to. I understand that the ranking member has a unanimous consent request. I do want to state this: this committee has a practice of only accepting sworn testimony. We're going to be asked to accept a letter signed by a number of organizations, which states in its first paragraph that they're submitting a statement for the record in advance of the hearing. I want to say that we only became aware of this at 7:15 this morning, and we have not had time to fully review this statement. In this case, it is not a letter, but as I said before, a quote, statement for the record, unquote, which does not follow the tradition of this committee for sworn testimony. Moreover, this is a point of personal privilege for the chairman. One of the groups who have signed this letter, for the record, have repeatedly circulated false statements about the chairman and ranking member, and have repeatedly and purposely misrepresented the serious and important work we're doing here on behalf of patients, families, healthcare providers, and the public. They've repeatedly and deliberately misrepresented the committee work with false statements. Thus, in this case, submitting a statement for the record without it being sworn testimony is of concern to the chair. And I yield to the ranking member.
Thank you.
for her
Well, Mr.
statement.
Chairman, I would ask unanimous consent to place a letter dated April 25th, 2013, about the position of these organizations regarding HIPAA. It's signed by the American Civil Liberties Union, the Autistic Self-Advocacy Network, and the Baseline Center for Mental Health Law. And I would ask unanimous consent to put this in the record as the opinion of these organizations. As we've discussed before, I've been on this subcommittee now for 16 years, Mr. Chairman, and it's always been the practice of the committee to take testimony under oath, and you are absolutely correct that this letter obviously is not under oath. It has also been the practice of this committee, though, to get extensive information from folks who might have expertise or opinions or otherwise. And I've seen this happen numerous times from both sides of the aisle. Simply accepting a document into the record does not necessarily imply agreement with the position stated in that document by either the chair, the ranking member, or any other member, but rather it helps to give a more full picture of what people think. But I agree with you. I do not consider this April 25th letter to be testimony or to substitute for testimony. I believe that it is a statement of that group, and we have done that. I've got many examples here I could give, but in the interest of time I won't. I simply ask for the chair's comity in putting this in and look forward to working with you so that we can clarify documents that will be put in the future. I would also note we also did put a article from Sports Illustrated in the record today. So it seems to me this letter would be appropriate.
I thank the ranking member, and out of my respect for the ranking member, understanding some of the unique circumstances of this, in this case, with unanimous consent, we will accept this into the record at this time, and the majority will also put a statement in along with that. I do want to thank the panelists today. This, in our continuing our series to deal with this critically important issue for the American people. Not since John F. Kennedy was president, I think, have we had such a focus on the issues of mental health and mental illness in this country. Your statements today, the passionate statements from the family members, and again, our sympathies and our prayers go with you. The expertise, Dr. Martini, Ms. Levine, Ms. McGraw, and those on our first panel, I ask that you stay in contact with us. We have a great deal of respect for what you have given to us today, and we look forward to working with you. I almost might say this. I would like to also add this. I'm very proud of the committee members on both sides of the aisle. I think that the members here have shown their absolute dedication to work in this. The statement we had earlier today, there's something like 38,000 suicides, 700,000 emergency room admissions for people who have attempted harm to themselves, and all the issues involved. This committee is focused more than any other subcommittee, I think, in Congress, in our memory, has worked on this. And I deeply thank the ranking member for her compassion and her passion on this. I also thank Mr. Braley for his bringing Ms. Thomas in today. Again, thank you all very much. I'd like to say in conclusion, I remind members they have 10 business days to submit questions to the record. I ask the witnesses all agree to respond promptly to any questions we afford to them. With that, this committee is adjourned.